Akin to item number 39, my lord, Lordship is hearing the matter. We have an exactly similar matter. There it's a case of an STP. It's not before the Lordship's list today. That is WPC number 619 of 2025. May I pray, my lord, both the matter may come tomorrow or any other day. It may be convenient to Lordship.
You are for the.
I'm in a matter which is not before Lordship. Exactly on the same point.
You are for the petitioner.
No, there I am for the Bongaigaon refinery.
And here
Here my
I am
learned.
appearing for the Guwahati refinery.
you are for the petitioner.
No,
For the
we are
respondent.
both in both the cases. Exactly identical point issue is involved.
So why the urgency that must
No,
be?
there is no urgency.
In my case, there is urgency because there is a stay order.
Oh, in our case also there is a stay order.
Right. Then this item be listed along with WPC number
619 of 2025
619 of 2025.
after the vacation, madam. Yes,
28
along with the connected IS.
along with that.
I have a small query as regards item of 17 and 18.
17
This is for the petition, Malad. I obtained the consent of the other side. In item number 18, they filed recently an agenda. Malad, I have to go through it, Malad. So some accommodation, Malad. Can it be immediately after vacation on 15th, Malad?
Wait. Petitioner has given a consent.
Yes, there is a stay order. That is urgency is on our part, Malad. That is why my humble prayer for Lordship.
17, 18 matters then referred the request made by the
15th of July is convenient to my lord. And my lord, I take.
You are appearing for in the 17 and 18 matter.
Yes, ma'am. My lord, my humble submission, I want to hand over, if permitted by lord, one convenience note and one judgment of
We
interim
will
order.
have it on the next date.
Okay. Yes, sir.
Let us have it on 17. You want 15?
If it's convenient to my lord,
All right, 15th of
Highly obliged.
my lord, interim order to continue.
interim order.
Inside order in item number 18 only.
Item 18. Did you
Clap together all matters, 17 and 18 all clap together, my lord.
Yes.
So interim order to continue.
So he says only in item number 18.
My
lord,
Exactly,
my
in
lord,
item
can-
number 18 only the interim order is
My
applied.
lord, 25th of March order of Justice Suman. And both the cases clubbed together, interim order given.
Interim
And
order.
not only my lord, in the similar two petitioners filed this petition in the internal bench also.
We
What
say
interim
that
said.
interim order past will continue in items
Yes,
17 and 18. That's all.
Yes, ma'am.
We are not.
If-
There is also the DP has been stalled because of the interim order apparent in item
You
number
are praying
18.
for time,
My lord,
but you are praying for time today.
my lord,
Let it be on 15th
my lord.
of July.
Highly obliged.
Not only my prayer, my lord, for lordship, my lord, item number 29 and 30, my lord. Since there is urgency, my lord, in the case, my lord, so my lord, it may be taken, my lord, since matter relates to pension of the wife and
You want to upgrade it.
yes,
Have you informed the other side?
yes,
Inform the other. Take up.
only for pension matter, my lord, because only discipline proceeding was there, expert in discipline proceeding.
Item
That
29,
the person has been an expert, my
29 and 30.
lord.
You want an upgrade
Yes,
today.
Yes.
You inform the other side.
Yes.
Your lordship. I get item number 2, your lordship.
Item
2, your lordship. So, can you pass the
item on whose behalf you have
on ARP, your lordship.
item then referred after court.
May I please, your lordship? Lordship, regarding item number 23 and 24, we have a joint prayer, lordship. I'm for the respondents and he's for the petitioner, lordship. The matter may be taken up after vacation, lordship.
23, 24, a joint request and referred after 4 weeks. Third week of July.
Most of
May I please, your lordship? With the consent of the other sides, I beg to mention item number 12 and 32 of the daily list.
12.
12 and 32, lordship.
In 12th, my lord, I am for the petitioner. The arguments were heard by your lordship. and only the judgments are to be placed, your lordship. The matter may be taken up the last week of June, my lord. Date will be given.
Last week of June.
Only we have to place the judgments and reference to that effect.
I think there are some judgments that
Yes,
should not
ma'am.
be.
We are ready with the judgment because the counsel for the respondent is not well. So, sir, we have also given a copy to them.
Twenty-four.
Hello.
Item 12 and
32, Lord.
32 I am appearing.
13.
32.
30. 30. What is 32? What matter is it? What is the subject matter?
Promotion.
Promotion matter. That we can have it in July.
Only thing that already date may be fixed.
Right. 32 come up on 30 of July. 30 July.
30th of July. Well, let it be on a hearing day, my lord.
Let it be on 31st.
My lord, my lord. 30th of July.
Highly
Published.
obliged.
If I may, Lordship. Lordship, I beg to mention item 28 and accompanied with that item 27, Lordship. I'm here on behalf of Mr. G. Rahul for the petitioner. Lordship, he has been extremely unwell for the last few days, and he prays that the matter may be heard on any other day after the 25th of July, Lordship. We have taken consent from the other parties involved.
And item 27.
Similarly, Lordship, it is tagged.
You're appearing in 27 as well.
28, Lordship.
Who's for 27?
27 is Miss S. Parveen.
That we can see. Have you informed them?
Yes, Lordship.
728 on a mention. 28 on the matter stands referred to be considered after 4 weeks.
Lordship, may kindly fix a date.
Item 28 is all council, full council. Happy to pay. That's submitted right now.
Lordship, may kindly fix a date.
It come after 4 weeks. Make a motion.
Extremely grateful, Lord.
May it please your lordship. Lordship, I beg to mention item number 25. Lordship, in this matter, we had filed an additional affidavit yesterday, which is not on record. Lordship, I'm praying for acquisition of the records.
Why have you filed it yesterday?
Lordship, because the instruction from the petitioner came on Saturday, and accordingly we had filed yesterday.
IPF, the respondent filed in 6 contesting responding in the matter. I may be allowed to obtain instructions in the matter fixed in any other date. They are filing, I got only in the evening. Yes.
What is the issue about?
It is about the benefit to be given to the petitioner with regard to stagnation in the service. What kind of benefit? She is already getting certain benefits, but she is claiming certainly more.
Lordship, may let the matter reach Lordship with the whole pending matter.
But you have filed some affidavit.
Yes, we
Yesterday-
filed an affidavit
So
yesterday.
why do you want to thrust it under our nose? Why don't you give us even the liberty to go through it? Have it on some other day.
All right.
The 23rd of List on 23rd.
June, Lord. Yes. Highly
May I please the lordship,
Yes.
with the consent of others, sir, I beg to mention item 8 with 9. It may be
Item
8 and 9.
9 and 10.
8 and 9.
8 and 9.
It may be
Yes.
listed after vacation.
On whose behalf?
On petitioner behalf, B. Prakash,
8 and 9. Then referred to it.
deeply obliged.
We have to pass an order, is it? We have to pass an order. What question to the finance department? The money has already been sanctioned. Fund was sanctioned, it is available with the board.
available with the court.
That is what
No, not available, my lord.
Ah.
It was used in for other payment, as because there was no sanction for the ROP.
Because the,
as on date you don't have the fund.
As on date, no.
because Lordship will kindly appreciate the materials on record inevitably suggest, my lord, that the government had taken a decision, okay, fine, you may adopt ROP 2017, but you have to give the benefits of ROP 2017 by way of generation of your own funds. Under the scheme
Then
of
why
the,
is the sanction of the government necessary if it is by generation of their own fund?
that is what, my lord, the finance department had given the
What
endorsement.
we are asking you.
Yes.
That is what we are asking the finance. If they are to use from their own generated fund,
Yes.
where is the occasion for the finance department to say that you may use, you may not use? It's their fund, they will decide how to use it.
Because there was a decision between the finance department as well as, my lord, the administrative department. To that
But
extent.
government has earlier allowed this. There is a government order sanctioning it.
Strengthening it at earlier one point of time because
Right.
there were, my lord, the, out of the granting aid which is given, because granting aid is not
And
given
your
for any,
letter also says it is subject to the cabinet decision. If I am not mistaken.
but there is no decision as such on record, available on record, which should suggest, my lord, even remotely
Page 30.
that, my lord, the government has taken
Notification
any
page 30,
decision
your lordship.
or the government has given any approval that, my lord, funds will be released or funds will be provided for extending the benefits of ROP.
So in the
Appro-
order, impugned order, pass order, we thought we'll pass it in court, but it will be a slightly long order. We pass it.
Because admittedly, these employees, 30 board employees, they are not government servants. 30 board is a separate juristic entity
There is no-
altogether.
There is no quarrel on that. They're
Yes.
obviously not government servants.
Yes, and the
Lord, here, your lord.
Does it disentitle them? We are only faced that they're not entitled to the pay revision when earlier occasion the
6 times they
decision was taken by the government.
I
Your
have given, I
lordship's
have
court-
given, but not as a right. There is no vested right accrued in their favor, my lord.
There
That
is-
day.
There is no vested right.
Yes. So therefore,
The government also will have to give reasons as to why the earlier decision has been reversed.
the
What
reasons
does-
are there. Reasons are there in the input order itself. Lordship will find. My lord, page 53 of the writ petition.
Hmm.
Kindly see, my lord. There was a total mess of affairs, my lord.
No, this has been disputed on the basis of documents that their accounts and everything have been sent and audited.
So audited, but the recent audit report, the updated audit reports and all those materials are not available on record.
It is there.
We'll pass order. You should get it by tomorrow.
That impugn order 2018 notification they refer to is without application of mine, as I said earlier, because of page 30. 2018 notification.
Order.
Deeply obliged.
I'm obliged.
But I have given one judgment.
Deeply obliged, man. It's a
Judgment Odisha.
Odisha High Court, yeah. As well as the Supreme Court. We have gone-
We have also relied on some judgments of copies of which have been submitted.
Yep.
yes,
I'm so obliged.
ma'am.
not abrogated by me, but not chosen by the registry. There's an order of this honorable court that it should have been mentioned at the top of the list, and it was not done. Therefore,
Legal aid matter.
no, Your Honor.
Then-
This is a matter with regard to an appointment of a person as a junior manager before the AEGCL. So my learned friend, Mr. J.K. Goswami's presence might be required here. Uh, if I may take your lordships to the
Why is it
petition.
updated?
No, it's lordship, the registry has made a mistake. They ought to have put it as the top at serial number 1 by way of a judicial order, which was passed on the last occasion. It ought to have been listed as item number 1 of the admission column.
Your earlier order does say
It says,
it says that at the top.
at the top of the list. Yes, it is not updated by me. They have. Then, may I submit your
Yeah.
Lordship will find that there was an advertisement which was issued in the month of in the year 2023, and thereafter a recruitment process was initiated by the Power Department in consultation with the AEGCL. This was for appointment of managers, junior managers, in the AEGCL. You'll also find the advertisement at page 33. If I may take your lordship to that for a moment. Annexure B, page 33. Have you lordship got it? The column number 3, lordship, reservation of posts. Junior manager electrical, the first one, name of the post. You also will find on the right-hand side, extreme right-hand side corner, post reserved for persons with benchmark disabilities and type of disability. That's the second last column, Your Honor. I'm reading from the second last column on the right-hand side.
Yeah.
For posts reserved for persons with benchmark disability and type of disability, 9 posts are reserved, of which BL is backlogs. There are 6 backlog vacancies. Then LV is low vision. There are 3 vacancies, and locomotor disability 3 and thalassemia 3. This has been explained by way of a star mark at the bottom of this column, Your Lordships. At the bottom of this table, you will find, Your Lordships will find BL backlog. Lordships have found it?
Yes.
Yes. Now, next page, Your Lordships, page 34. For persons with benchmark disability category candidate, I'm reading column number 8, Your Lordships. This is the eligibility criteria. Point number 8, page 34. To be eligible for consideration under PWBD category, a candidate must possess benchmark disability and must produce necessary certificate issued by the competent authority. Just will kindly note, competent authority. And also the application must be supported by necessary PWD certificate issued by the competent authority. Then next, column number 9, point 9, other terms and conditions of appointment.
Yeah.
9A, the candidates provisionally selected shall have to undergo pre-employment medical examination before joining AEGCL. Candidates should have sound health and should meet the medical standard prescribed by AEGCL. Appointment of provisionally selected candidates subject to satisfactory medical report from the medical officer of AEGCL as per the medical standards of AEGCL. No relaxation in health standards will be allowed. Now, one more column here in page 35. Towards the center of the page, there is a point which says persons with benchmark disability. Page 35, center of the page.
Yeah.
I'm reading that sentence for your lordships. Physically handicapped persons or persons with disabilities as indicated against various items in the vacancy details can apply to the respective posts even if the post is not reserved for them but has been identified as suitable. However, such candidates will be considered for selection to post by general standard of merit. Persons suffering from not less than 40% of relevant disability shall alone be eligible for the benefit of reservation and other relaxations as permissible under the rules. So basically, to apply as a person with disability, a person has to be at least 40%. The percentage of disability has to be 40%, Your Honor. And they had in the advertisement they had envisaged that there might be a medical examination which may be conducted. That was the basic case. Now, thereafter, Your Lordship, I have duly appeared. I appeared in the written test. I qualified. Thereafter, Your Lordship will find at page 40, annexure D, I was called for the interview, viva voce. This is my admit card to the viva voce. I again appeared and I was selected. Annexure E, page 41 is the select list. And my name figures at serial number 71 at page 42. Under the low vision category. I am 60% low vision, Your Lordship.
In the open category.
No, in the persons with benchmark disabilities. I am a benchmark disabled because I am 40% and above. So therefore, I am benchmark disability. I have the competent certificate. Certificate is annexed as annexure A of this writ petition. Page 30. Then thereafter, they invited us to come and produce certain documents and all that, which I have annexed, Your Lordship. And there was a medical board which was constituted by way of annexure G at page 44. Now, again, I appeared in this before this medical board, and considering the fact that there was no other problem with me, I was expecting that I would be appointed. Unfortunately, that appointment never happened. So when I inquired, I was told that the medical board, which was constituted by the AEGCL, has said that I am not 60% disabled, I'm 30% disabled. Now, naturally, I was quite overwhelmed by this because I have a disability certificate which says 60%. So I went and approached the authorities and they said that you better get yourself re-examined by the GMCH because our board has said that you are only 30%. So I did that as well. I went back and I re-examined myself before the GMCH, and that report again came out as 60%, which is page 50, annexure L. This is my second examination on the verbal instruction of the AEGCL. And this is from GMCH. Justice will find I have been visual impairment 60%. Again, signed by the director and HOD of the ophthalmology department, by the professor of ophthalmology, the registrar of ophthalmology. These are all their own authorities who have certified that I have 60%. Despite this certificate, when I produced this, they have refused to give me an appointment. Naturally, I approached this honorable court by way of this writ petition as to why is it that I am not being appointed against the post which I have been selected against. There are 3 clear vacancies. I was at serial number 3. I should have easily been appointed. Now, the AEGCL has filed an affidavit saying that they have, number 1, they said that at the point number 9, that as per the medical examination conducted by them, I did not come under the benchmark disability. That was their first stand. The other stand which they have taken is that they have sent my name to the power department, because the power department is the parent department allegedly, and it is the power department who will supposedly assess whether I am available, whether I should be appointed or not. And at that stage, we are stuck because the power department is yet to file an affidavit. By way of judicial orders, they were directed to file an affidavit, which they did not. Then on the last occasion, the court was of the opinion that if at all we require their assistance, we will ask them to bring the records, and no further time for an affidavit was granted to the power department. Now, insofar as the submission of the AEGCL is concerned, Your Lordship.
No, but tell us.
Yes, Your Lordship.
You applied to satisfy the criteria for
Yes, Your. Yes.
You go for a pre-appointment test.
Yes.
That also tells you that you are within the criteria. Now then, what is the process after that?
Lordship, first is the written test, I qualified. Second is the viva voce, I qualified. Select list, my name is there. Naturally, I am entitled. So the only thing left was a medical board examination, for which they said that you have to give some affidavit, which I gave. I went and appeared before the medical board. In the AEGCL's affidavit, you will find the medical board assessment, complete thing. Now, the medical board of AEGCL has said that you are not 60% disabled, you are only 30% disabled. Visual impairment.
No, the medical board which you appeared to the medical board of the state.
My disability certificate comes from the board which is by the state rules.
After the exam.
Yes, Your Lordship.
After your selection, after your name having appeared in the selection.
They formulate their own
government formulated, because we cannot. Because we all requested the government to constitute a medical board. Accordingly, government constituted the.
That medical board said you are 30%.
That medical board, you also will find that at page 66, running page 66 of the file. It starts at running page 65, actually. And the name of the petitioner, page number. Yep. Is at page number 80. 80, Your Lordship. Serial number 71. Now, my name is Hiranya Kolita, and Your Lordship will find the board's comments clinically fit, but physically handicapped of low vision with 30% category 2.
So your grievance essentially is against the report of the
This
medical board.
this was not within my knowledge. Now, when they filed the affidavit, I have filed an affidavit in reply pointing out the deficiencies in this report, and naturally saying that this cannot be, because the fact remains that under the Persons with Disabilities Act, the state has formulated certain rules. Now, this disability certificate of each person is issued on the basis of the act and the rule. Any medical board which sits to assess the medical fitness of a particular candidate is not to assess the particular disability. This medical board which is formulated is to assess the general feasibility of, if you also will have a look at the comments which are being made against each candidate, you'll also will find that they have just said things like, if I may just take one or two examples.
Let's begin with you, which says clinically fit.
Yes.
But-
And so against in all of these cases, they have all said clinically fit, clinically fit, clinically fit. Most of the candidates, one or two of them were absent. Then one or two, they have said that, again, let me take your lordships to page 77 for a moment. Page 77 at column number 45, at serial number 45. Lordships have got it. Again, they have said that physically handicapped candidate of low vision, after examination, candidate found 40% category 3A. Now, in my respectful submission, Your Lordships, this board is not the competent board to describe my disability percentage. This is a board which has been formulated by the AEGCL to generally check the physical fitness of all candidates who have appeared. This board, which Your Lordships will find, I do not know the names and the persons who were appearing in this before this particular committee, or this who were members of this board. It may be perhaps revealed from the, yes, from page 64. From page 64 of this of Annex 3 of their affidavit, Your Lordships will find that serial number 3, Dr. Mir Alam Siddiqui, who is an associate professor of ophthalmology, is a member, and Dr. Hinarmoy Das, assistant professor of, no, so we are only concerned with ophthalmology. Lordship. Baby Deka, professor of ophthalmology, member, serial number 2 and 3. हमारा वाला certificate for.
Yes.
Now, Your Lordships will find, if Your Lordships will compare this with page 50 of my writ petition.
But essentially, is that once you are given the certificate,
Yes.
there's no scope of reevaluation.
There's no scope of review. Only the competent authority, the competent board, which is constituted under the Rights of Persons with Disabilities Act, as well as the rules.
We'll need the health department to be arrayed as a party here, because the medical board has been constituted by the health department.
Yes, but then that is not under challenge in any manner, because the rules and the act is very clear. The board which issues the certificate.
In fact, there are a bunch of writ petitions which I am presently being heard, where this is the very issue, that whether the subsequent medical board will have the power to reevaluate once you have that
Correct.
certificate or the, what do you call that, card,
Yes.
because there is no other provision under the act. as
Correct.
well as-
Yes.
It's the very,
The state rules also are very clear in this. I've annexed the state rules in my affidavit in reply, wherein I have stated very specifically that the rules of the Assam state rules are very clear that it is only the competent authority in terms of rule so and so which can issue the disability certificate. So the medical board which is formulated thereafter is to assess the general fitness of candidates, Your Lordship, in my respectful submission. In any authority, in any organization who conducts a recruitment process will certainly have the right to medically examine their candidates. For example, in one of the candidates, this thing, there was a noting which was written that the candidate suffered from sickle cell disease. That is completely within their competency to hold that kind of a thing. But to reassess my disability, that is not the power which has been granted to this particular board. And then denying me appointment.
Who's appearing for the disability commission?
Lots of disability commission, I think it would be the government who normally appears.
Respondent 5
Party kora আছে, কিন্তু no one has appeared, Your Lordship, to my knowledge.
for respondent 5 person commissioner for persons of disability government of staff.
I normally RM Deka, Mr. Deka appears for it, but I'm not sure whether he's no RM Das. RM Das. RM Das appears for it,
Then please
and I'd served notice on him as well. I will, Your Lord.
respond
6 has been impleted by order dated 20/12/2024. So respondent number 6, my learned friend Mr. Goswami appears, JK Goswami. He's
who's the respondent.
the power department, Your Lordship, power electricity department.
It is the state,
And-
Lordship. It is the state.
He's standing counsel now. But he's been handling the case. तुम्हें अपने को पड़ेगा? In fact, Your Lordships, Annexure L, which I was taking Your Lordships to, it is the same person who sat on their board and who has thereafter certified my 60% disability again.
Lordship. The dates are similar to what is there are number of jurisdictions are being adjudicated, Lordship, and this is I think further before your Lordship. Lordship may take this matter with that where our Cadet AG is appearing in that matter, Lordship, on behalf of the government, Lordship. And this is also regarding the same issue, Lordship. The review medical.
He took that in hearing. Whether they take the subsequent that where the health department is the part.
Then I can certainly, Dr. will give me an opportunity. I can make them a party respondent. That's not a difficulty at all.
Make them part of the
Lordship. I'll file the amended cost title, and Your Lordship may kindly allow me in terms of that notification of the High Court, where I do not need to file a miss case separately for impleading him. I can just simply file the amended cost title. I can do it within a week. Your Lordship.
are
1, 2, 3.
In my opinion, it's the number 488.
Third?
They on behalf of these are
anyone else.
I'm appearing on behalf of respondent number 6, Lord.
The director. Point. Election. Indicated by the Assam State Portal. What post is it?
Junior manager electric.
You can say that. It will be done. The video category. Go to the petitioner and hear the step. Further subjected very clear by the here where your opinion people put that after the ability of therefore when people be when part right here and therefore the point there any communication saying that you've been rejected?
No, only a verbal communication, Your Lordship, that because of this,
Yeah. Yep. Yep. Right. Bye. Yep. Oh. During course of the head, that that is by the whereby the medical board had settled the medical and thereby state for the corporate the disability certificate by the terms of Disability Act as also the get by another the act that for further medical review while identify a person belonging to the disability indicating the category of disability issue. The certain not that required that the bill produced and may also have the who was the rate of the part
respondent 6 was incorporated as a party respondent by way of order dated
partner
Power Department.
our negative part. There are at the same time that that heard and the matters are likely that might be telling the date.
Yes, there is no fixed date, Lordship, in the month of July after reopening. And the WBC number is 2301-2024.
The number
2301-2024.
301
2024.
and the are further about that the health department the health department very health department considering the permit done in the department by that they you know what we the family that reporter partner again the number again
2301
of 2020.
301 of 2020.
Lordship, on last occasion, actually record was called for, but we have received record, but these are all the photocopies, Lordship. So I will again copy the original record.
and which of the commissioner?
Lordship, they do not have the authority for issuing any certificate. That's not the competent authority. They're just a formal party because they.
Put the hotel department. Simply the health.
It's the health department.
Health department.
Only the
Health,
health.
Yes,
Health
Lord.
Yes.
Social empowerment.
Social empowerment department looks after the well-being or welfare of all the persons with disabilities.
Is it?
But the competent authority, the board which is constituted by the health department.
So we have it in
July.
Lordship. End of July, Lordship, no date is fixed.
We-
This matter.
Let-
Yes,
we have
Lord.
directed
Let
the
it
matter
be.
to be
Let it be
listed.
listed. with
Yes,
those-
Lord.
You are entitled to make a mention when the court.
Deeply obliged.
Deeply obliged.
Oh, pleases your lordship. Lordship, similar matter was.
I think you have not submitted any extra copy.
Please, I think I have taken step. I have taken step.
Madam.
Earlier I have taken. Otherwise,
Appointment.
yes, lordship, this can be disposed of as per the order of.
Share it with the government council if you agree
Yes.
with this.
Yes. We can wait. Listen for that. But, let us consider.
Yes.
Need-
You go,
Okay,
we take it up at the second half.
Yes, Lord.
Follow up.
At 2 lot.
Yes.
Deeply obliged.
But here, although the responsible act should file a affidavit, but no affidavit has been filed today. So, the matter was.
Yes.
But the respondent was supposed to file their affidavit. Number of occasions they have taken time. In fact, on the last occasion, the court observed that in case they do not file, the matter may be taken up for disposal.
Yes, lordship, here we had filed a affidavit in opposition. We filed a reply and additional affidavit. On the additional affidavit, lordship, I sought for instruction, and the instruction that I have received, lordship, is just 2 line, lordship. I don't think any affidavit.
Here, I was being paid this 7th pay, revised pay in accordance with the 7th pay commission. All of a sudden, from 2018, it was stopped. On the ground that the finance department said, there is no government approval. Thereafter, although I was during the pendency of the repetition in 2023, they have again released my salary in terms of the 7th pay commission. So only thing is, the area remains. Earlier, I was being paid till 2018. In between, we were stopped from April 2023. We are all being paid the revised pay as per the 7th pay.
You are an employee
of ASCA. This is a sister concern of the agriculture department. Exactly.
So you are being paid revised pay.
Yes, I was being paid till December 2018 under the 7th pay commission.
Then why were you stopped?
Suddenly it was from part payment was made. Then the finance department came with the ground that since there is no government approval, there was no approval, that is why it was stayed. Therefore we filed the petitions. Initially, whether the condition was whether we are government employees or not. If your lordship kindly come through the order dated 1/8/2023 by Justice Pathak. 1/8/23. This has led to rest that we are all government employees working in a sanctioned post. And in fact, there certain queries were made, and we, in fact, subsequently we filed two affidavits bringing on record whatever documents were there. And in fact, from 2023 April onwards, we are being paid. Now, what remains is the area part.
There is no finding that you are government servant.
No, in fact, yes, we'll just take it, Page 50, paragraph 15 and 16,
Huh?
Paragraph 15 and 16. 15 and 16 of the order,
Yes.
The above clarifies that the Agriculture Department in its 54th governing body meeting gave its post-facto approval for payment of revised payment of salary to the employees of the ASCA since there was no government notification regarding granting of such revised scale of pay to the employees of ASCA. The said proposal could not be considered by the Finance Department of the state, due to which the employees of the ASCA were not extended with the revised pay scale so and so. From the affidavit of the Secretary to the Government of Assam in the Agriculture Department, as noted, it is seen that the employees of ASCA are working as sanctioned posts granted or created by the Government of Assam, and those employees are drawing their salaries since inception in accordance with the revision of pay rules as per the employees of the state. Considering the above, both the petitioner directive, there was a direction to file an affidavit. Your lordship will find the affidavit at
Where is the finding that you are a government?
No, in fact, this is what, Lord. In fact, because
that by this order, there is a finding that you are a government.
So the affidavit speaks for that is what finding. It's an observation, No, I cannot say in the
Observation that you are working in a
sanction post, yes,
Yes, section.
but the documents, will go to show that we are a system person of the agriculture department. Everything, Your lordship kindly takes up the affidavit, which is 5172, running page it will be 167.
Where whether your appointment can be considered.
No, only thing, in the first order.
There are what is whether you are entitled to this benefit or
That is the only thing, there was a
or only for whether you are entitled to device.
loss.
Whether you are a government servant or not.
No, the problem is, on the first order, there was an option regarding mentality of the case. Well, that was late to this. That is why I'm saying, because initially, whether the repetition is maintainable, whether we are government,
whether you are entitled to device fee or not necessarily dependent on the fact that whether you are a government servant.
Exactly. That is
part. but then you are entitled, but by
Lot,
exactly. Now, if you are arguing that oh, you are otherwise the government servant, therefore entitled.
In fact, my lord, the transfers were made from the executive department to the ASCAB against sanction force. And even my lord, the rule says,
Because
I understand,
whether
I understand, I understand.
board or a body is paid that you have the employees from somewhere.
True.
Either to run the
No, even otherwise, my lord, even if the ASCA say, my lord, for some reason, my lord, there is 34, my lord, probably. I'll just take it.
now have any proposal with that
The
figure?
proposal, in fact, my lord, I am receiving. That is, your lordship will kindly come to page 167, my lord. This is the additional affidavit file, my lord. In terms of the order, my lord, this affidavit was fine. Running page, it will be 167. Lordship has got it.
167.
And lordship may come to annexure 5 at annexure S at page 173. 73. We have annexed the documents starting from 2010.
What does the cabinet memorandum say?
Lordship will just take you to that. Page 187. 187, Milord, page 188 would be relevant. Clause 7. Clause 7B. And page 189, Milord. Page 189 is clause 2.
One 189 is to with regard to waiver of certification fee.
No, 189, Milord, cabinet decided the cost of approximate certification so and so, and decided that grant in rupees 50 per annum be provided for 3 years over and above the salary component. And in fact, if your lordship goes to the next page, from 2000
These grants in aid are provided what purpose?
for the salary, Milord. And in fact, I think if your lordship here the financial sanction is Milord accorded by the executive department. They receive the funds and they credit the amount to the ASCAM for the purpose of the salary. Now, lordship will kindly come to the next page then. And actually W at page 190, Milord. From 2000, Milord, from 1st of April 2023, Milord, we are again receiving the salaries in terms of the 7th pay commission. And in fact, 190 is the sanction proposal. Now, lordship, you will find everything here, Milord. And page 202 is the utilization certificate. 202 and 2003, Milord. And page 204 is the financial sanction. So the Milord, salaries for the period with effect from January 2019 to March 2023 remains.
But what is that page 20?
Utilization certificate.
That is for 22, 23.
Yes, Milord. Now, because Milord 23, unless and until we file submit the utilization certificate for the previous
So you are asking for which?
from the period Milord, since presently we are receiving Milord. So from January 2019 to March 2023. Initially, it was for the we prayed that we are otherwise entitled to the revised pay scale. That was not given to us. With effect from 1st of April 2023, we are being paid.
You are being given grants in it.
True, Milord.
Can there be a right of that?
No, Milord. Since earlier I was getting Milord, now I am getting Milord.
Grants in it. Getting only grants in it.
Yes, granted for the purpose of salaries, Milord. That is what.
You must pay grants to include all this. You're a government servant, you're paid different. You are given a salary. Division of pay takes place, you're entitled to it. Increase in the pay. That is okay. But it's the case where you are trying to get benefit of the division of pay given to state government.
True.
Ordinarily, it was from your own your employee, whatever
The problem is, Milord, from this.
but you are asking grants in it.
From the
giving you grants in it within the whatever calculation they can direction that
the only thing, you know,
grants in it, continue to give grants in it.
from the very inception, that is what is going on. The
Maybe ordinarily they but
yes, true, Milord, because only if Milord, otherwise we are not entitled.
what that right?
Because Milord, in fact, Milord, that is why I'll just
They nothing but a aid.
True, Milord. Create an aid for the purpose of this for the purpose of the salaries, Milord.
Correct. But can there be
Now, Lordship, why I am insisting, Lord, Lordship will see.
you're asking to break for a matter?
True. Now, Lordship will see most of the employees were earlier working in the agriculture department. Once this,
they have now been absorbed.
Lordship, no, Milord, no, there is another thing, Milord. There are documents to show that they are being transferred back, Milord. And in fact, Milord, in the earlier affidavit which was filed on 6/5/22, Milord, I'll just take you to paragraph 3. Now, rule page 3, paragraph 3, Milord. The earlier affidavit filed by us, Milord, additional affidavit on 6/5/22. Additional affidavit, Milord, filed by the petitioners. No, Milord, 6/5/22. Additional affidavit.
Affidavit filed by the petitioner.
petitioner. So Lordship will kindly come to paragraph 3, page 3. I'll just take you to Milord, down to Milord, this starts for further.
Yeah.
Further, Rule 34 of the rules of the State Seat Certification Agency provides that subject to the provisions of Society Registration Act and with the approval of the state government, the society may be dissolved by the resolution passed by at an ordinary general meeting of the body, duly convened for the purpose, and supported by more than 3/5 of the total number of members of the body. On such dissolution, all assets and liabilities of the society shall vest with this in the state government and shall be dealt with in such manner in the government may direct.
Where else will it be after the
So, my lord, so ultimately everything will, even the staff, my lord, they will be absorbed back. Now, Lordship will see.
You show us that the petitioners are still in the employment of the state government. They are the land.
Yes, yes, my lord. In that case, my lord, this affidavit will suffice me. Now, Lordship will see. I'll just take you to page 7, my lord, of the affidavit. Now, this is a order by the government of Assam, my lord, where the name of the organization was changed. The governor of Assam is pleased to grant organic certification power to the Assam State so and so, and rename it as the Assam Seed and Organic Certification Agency. Additional signed by the additional chief secretary to the government of Assam Agriculture Department. Everything is, my lord. The next page, my lord. This is of.
No, what are you trying to say? You are an organization formed by the government.
True me.
That by itself does not make your the employees giving them the status of a government servant. You're not a government. Unless you say that you are otherwise an employee of the state, you are sent on deputation. And you have not been absorbed.
In fact, my lord, the writ petition itself, my lord, we
can take a decision that yes, they may be a organization, not a part of the government, but essentially they're functioning, they're rendering essential government function. We give them the benefit of revision. But you are both the court praying for a bandama.
True. Here in the writ petition itself, we have annexed documents to show that persons were deputed to this organization.
What? Yes, respondents, what is
Lordship, here the certification agency is a statutory body under the state act. Initially, at the formation of that agency, Lordship, personnel from the agriculture department were deputed to their post. Subsequently, Lordship, only those posts that were created against that, those posts, whatever the salary component is there, that is given in granting aid. That is till now it has been given, and the adoption of the pay commission shall pay. Lordship, it's the board who will adopt it, and they will have to get the difference between the granting aid and the sub pay commission scale. Lordship, from their own sources, like from the certification fees and everything that they undertake. Lordship. And they were receiving the granting aid only in Lordship. The objection raised by the finance department, it has been in 2019, that has been page 85. Lordship, it will be third paragraph. I'm reading the whole letter. I'm directed to state the finance EC1 department observation from the pay commissions constituted by the government at periodical interval provides enough revenues for various services and cadres to represent their demands before such commission. Once the report of the pay commission in the form of recommendation are submitted to the government, the same is examined and placed before the cabinet for approval. This examination at the level of the government is done to ensure that all concerns and demands of various stakeholders are adequately addressed. After publication of ROP, The existing mechanism provides another opportunity for redressal of any genuine grievances to anomaly committee. Against this backdrop, Finance PRU department observes that there being no such recommendation of 7th Assam Pay Commission or Anomaly Committee for allowing the revised pay scale as per ROP 2017 to the employees of Assam State Seat Certification Agency. Finance PRU department regrets the proposal for extending revised pay scale as per ROP 2017 to the employees of Assam State Seat Certification Agency. It is only on the observation of the finance department, lordship, the granting it with regard to the pay scale under the ROP that has been. Otherwise, they are, as per the instruction also again received, they are receiving the scale under 2010 ROP.
Up to page number 03. Up page 190. 190. The proposal then.
Yes.
To the amount of 20. Only again salaries and allowance. Was this amount sanctioned?
This is a sanctioned proposal.
This amount is sanctioned at page 08.
Yes, Milo. This is what, Milo. Financial section for the year 2023-24. This was dated 29/7/2004. 29/7/2023.
Sanctioned.
The sanction was accorded. That is what, Milo. Sanction was accorded from 1st of April 2023 again. And as of now, we are receiving the salaries in terms of the 7th pay.
So if they are entitled to receive it, that were found they claim to be entitled to, will have to be, if you are agreeing to their proposal.
Lordship, this proposal is there for 2023-24, but whether the salary component was as per the ROP 2010 or 2007, that is not reflected. It's the sum total of the proposal. It has been reflected.
And what about the which period are you referring?
From 1st January 2019 to 31st of April, 31st of March 2023.
Where is the proposal?
The proposal will initially, we came there since we were not being paid, we came to this court. And during the pendency of the petition, from 2023 onwards, we are being paid. So,
this is the only return, or you have come earlier?
So we have come earlier. This is of 2019, pending since 2019. Now, only thing, since we were stopped, we came to this court. During the pendency of the petition,
what orders were passed with the earlier rate?
So this is the first petition. This is the first. This case is pending since 2019.
Where is that proposal? Somebody has to make up a proposal and put it in the government.
That is why, in fact, proposal, if a lordship,
it must come from your corporation.
No, lordship, for a moment, if a lordship goes to the earlier affidavit, 6522 . normally what happens, my lord, the affidavit that, my lord, dated 6/5/2022.
Yes.
Now, lordship will kindly come to annexure P1, page 9. Lordship will see this is the demand for grants for the year 2018-19. Now, if your lordship kindly come to the next page, down below, my lord, 1034 Assam State Seat for the Certification Agency. Total 31 grants in next page, page 11. Grants in 8 salary 65.57. This is will be in crores. Now demand next page, my lord, for the next year 2019-20, page 13, my lord. Total 103 for Assam State so and so. And in fact, at page 15 is the, my lord, sanction. Sanction is being accorded by the Executive Department. Page 15, annexure Q. Financial sanction is being accorded by the Executive Department
For that period.
for their period.
So this is for financial year 21-22.
22. So it is the request for grant, my lord. It is raised by the.
No, but does it include the salary, the scale of ROP? Which ROP you are asking for? 20.
2017.
2007.
Does it that? No reflection here.
Now, lordship will just rely on another document. Lordship will page 18. Is the, my lord, principal account general? This is there. The lordship sees page 18 of that FAP, my lord. I'll take you to page 20. An inquiry was raised, my lord, by the assistant audit officer of the AG, my lord. Page 20, my lord, of that FAP. My lord, initially, my lord, in 2018, my lord, it was as per the ROPs 2007. Now what? 2017. Now what has happened, my lord? Instead of release of 254, 150 crores was released, leaving out 105. That started the problem. Now, lordship will see page 20. I'm just reading out. After creation of the agency in 1985, a total of 4 times pay revision entertained by the seat certificate agency on the basis of the 4th, 5th, 6th, and 7th pay commission as equal to the staff of the state government. As per 6th pay commission, the salary of the officials of the seat agency was revised as per state government officials with effect from 1/4/2006. When 7th pay commission was implemented with effect from 1/4/2016, as ROP so and so, the revised pay of the officials of the seat agency were equally with the salary revised by revised for the state government employees. As per 7th pay commission, the salary of ASCA officials were revised and drawn from April 2016 to December 2018 as normal activity. But the government of Assam Agriculture Department regrets the proposal for extending revised pay scale as per so and so, and directed to resubmit proposal for sanction of the pre-revised scale as per 6th pay commission. The reason for allowing the 7th pay commission as stated was due to non-recommendation of the 7th pay commission for revision of the pay to the employees. From the above, the following points has been observed. The ASCA is created by the government of Assam. Post and scales are created as equivalent to the state government. Budget is prepared and submitted to the Agriculture Department for sanction of grants. Salary is met from the grants and aid received from the state government. Sanction posts are transferable from the office of the state government. Pay of the ASCA officials were revised as per recommendation of the 4th, 5th, 6th commission to the state government. This could not be avoided from all facts above that the ASCA is a part of the state government. So, since it was stopped, the sanction was being sent to pre-revised format.
Right. Where can be.
Otherwise, we are entertainment. Only thing Lord will see.
You are surviving.
True.
Yeah, but that particular
No, no.
case. Whenever necessary, government has taken a decision that the of
No, my lordship, all of us, I was being paid. All of us, it was there. There
may
has
have
to
been
be.
paid, but doesn't entitle.
I'm being paid now, my lord. That is what I'm being paid now. My lord, if I otherwise I was not entitled. Presently, I would not have been paid, my lord.
Where the dejection letter?
Page 85.
Page 85, lordship, and I cut it.
Even below the finance affidavit, my lord, it says
17th October. 17th October.
Yes, ma'am.
yes, my lord. The lottery will kindly come to page 75 past me. That will clarify, my lord.
Page number.
Page 75 is the initial rejection. It's dated 13th of February 2019. Lottery is got it. Sanction proposal for ASCA during 2018-19. With reference to the subject, I am directed to say that the finance ECS so and so observe that since there is no recommendation to the seventh pay commission for revision of pay to the employees of ASCA, hence the proposed salary as per the seventh pay commission cannot be considered by them. Below thereafter is this reply at page 76. In inviting reference to the subject cited above, I would like to apprise you that the staff of ASCA working in sanctioned posts by the government of Assam have been drawing their monthly salary, etc., since inception in accordance with the pay commission recommendation. It is worth mentioning that the salaries expected were drawn for the year 2017-18, including the additional budget 2 as per the 7th pay commission. But unfortunately, this time, for 2018-19, the finance department is declined to consider the proposed salary as per the 7th pay commission in favor of the employees belonging to ASCA. Ultimately, we had to resubmit the budget proposal in accordance with the pre-revised pay for the financial year 2018-19. In the meantime, a letter is received from your end, dated so and so, under reference, where 150 so and so lakhs is sanctioned by for payment of salary expected to the ASCA so and so for the year 2018-19 against the budget proposal of 265. So, 115 was left out. Now, the remaining proposed budget amount, that is the balance amount for the year is 15.20 lakh. Under the above context, I do like to request you to kindly expedite the process to draw the above mentioned balance amount for the greater interest of the farming community as a whole and the employees of the ASCA in particular. Now, thereafter, my lord, this page 78. This is regarding approval. Approval of revised pay structure as per ROP.
That's by the corporate.
Yes, ma'am. No, it is ultimately, it is the corporation sends the proposal to the executive department. This is the process. These are on record. With reference to this so and so, I'd like to submit that 2 copies of revised pay structure so and so for the employees of ASCA for kind approval of the finance so and so. It may mention that 54 governing committee meeting of ASCA held on so and so given post facto approval of ROP Rule 2017. Now, Lordship, page 17, and Lordship will see again. Last, my lord, that bottom, my lord, Assam State Seed Corporation Agency, and the salary component is at page 80, my lord, on the top. And thereafter, my lord, page 85.
Like what more of have completed They are giving it. What corporation justify to ask for the matter? If you practice,
Let me take a
if you think about
What?
even if we allow them to have some reverse but ask 1920, which one you get?
no, it was stopped from December 2018. So 1st of January 19 to
21.
no, my lord, it will be 23. Since 23, I'm being paid.
You're asking for that, right? Get,
We will get it.
think about on Tuesday.
Tuesday.
Finance have also filed an affidavit.
Tuesday. Do you have any authority?
Lot.
Okay.
Okay.
But there's a lot. Well, in this case, the petitioners are direct, they call what the direct payment workers. They are, of course, they are not the contract laborer, but they are employed by the FCI, but not the regular employee. The FCI may engage some regular employee, they are called the departmental worker, and apart from that, they may directly employ some other persons who are not direct departmental workers. And they also may engage some other contract laborer. Now, the problem is that, so far the direct payment system worker are concerned, they, after completion of certain amount of work, they are entitled to have incentive. But so far the contract laborers are concerned, they do not entitled, they are not entitled for any incentive. Now, under Contract Labor Regulation and Evaluation Act, Rule 25 to 5A stipulates that when they are, well, I have not brought my book, so I took the Rule 25 to 5A.
So you are not under contractual labor.
No, I am not contract labor.
You are direct what is the direct payment?
The direct payment system. So, if in an establishment, if there is a contract laborer and directly recruited employees are concerned, and both these two set of workers are performing similar nature of job, then the contract laborers are entitled to have the wage paid to the direct employees, directly recruited employees. That is the problem with the FCI. Now as we are the ancillary worker, but we are getting incentive, they want to transfer a set of workers who are working in FSD Tihu to Chalpa, which is about 600 kilometers away from Tihu. Now there is a circular in the FCI that if so far the ancillary workers are concerned, they should not be transferred beyond 100 kilometers. That is and an effort should be made so that they may be posted within the reasonable distance. Normally, I approach before this court because we have been transferred to a Chalkwa, which is 600 kilometers away, and this honorable court has also granted stay order for our application. Now they have also filed an application for vacation of the stay order. So that is the problem we are having in this case. So that is the problem. They want to transfer us from Tihu to Chalkwa only because they want to recruit some contract laborers. If we are working there, then this contract laborer will get wages as are being paid to us. That is the problem with the FCI. We don't have any objection that if the contract laborers are engaged there. That is the crux of the problem.
There is a writer in that circular that whenever if there is an exigency, then they can be transferred from beyond 100 kilometers. I will certify your lordship, madam. There is a similar order judgment by the coordinate bench where my learned friend has appeared. Similarly situated, my lord Great Fiction, that has been dismissed after observing many circulars as followed by the FCI.
Where is the circular? Let us have it.
Circular, your lordship will find Annexure C.
C.
Clause 1, the circular number dated 17/8 when it was advised not to ship the worker beyond 100 kilometers unless in cases of exigencies must be strictly complied with, as this particular point suggested by the Honorable Minister such and such. Circular number such and such also, circular number such and such dated such and such may also be referred during deliberating on the issue of rationalization labor. Said circular suggests that the gainful utilization of the surplus ancillary labor, it was suggested to utilize their service in depots, region, divisional offices, and even in the depots where the contract laborers are performing the handling work. Considering the above mentioned circulars, it is advised to transfer the ancillary laborers only if there is no any option to accommodate them either in the same depot or in the neighboring depot, as it may not have any significant impact of the handling cost.
Who are the ancillary labor? Direct payment.
No, ancillary laborers, yes, direct ancillary. But they are not the contract laborers are not the ancillary.
Otherwise, contract laborer get lesser pay.
No, contract labor, if an establishment, there is a two set of employees. One is directly recruited by the employer and other employed by the contractor. But if it is found that both this set of workers are performing same and similar nature of work, then the contract laborers are entitled to have the wages as being paid to the regular employee.
That's what I'm saying. Otherwise, contract laborers are paid lesser with it.
Yes, otherwise they are lesser. So in order to accommodate the contract laborers only.
Your submission is that in order, this is the cost cutting effect.
Yes, that is, they have also admitted it. So we don't have any objection to engage in the contract laborer, but they have some objection.
Then what is your difficulty in working in that new case of thing?
Because we are daily wage workers, getting minimum wages. Our earning is not more than 25,000 per month. So if we are transferred to 600 kilometers away from Tihu, then we have to face hardship. In order to mitigate this hardship, the circular was issued by the FCI themselves. But now they are also facing trouble. Because if they engage contract labor here, they may not require to pay the higher wages as being paid to us for performing the excess work. If the contract labor performs that excess work, they need not pay the incentive. But in case if we are there, They are to play the incentive.
What is the judgment? The thing referring?
Yes. It's been reported in 2020, 5 GLT 536.
Obviously. That is a defined issue, I think.
Same issues, man.
Yes.
Look, did it? I think, yes,
So I have a copy.
yes, sir. It is there.
What?
I have a
In the last occasion, we have submitted report. Paragraph 8, 11, 12. May I read it, ma'am? Para 8.
So you read the finding. The fact,
I will start from paragraph 11.
where are the facts?
Fact start from paragraph 8, ma'am. Wrongful standing counsel has strenuously resisted the submissions made on behalf of the petitioner by referring to the policy embodied in the guidelines issued by the FCI on 12/7/2016 with regard to the rationalization of existing manpower. He has submitted that the impugned transfer order has been issued in due adherence to the policy in force. The order of transfer of the petitioners which are in nature of inter-region transfer are made between the FSDs which are notified depots and which are exempted under the provisions of contract labor Regulation and Abolition Act 1970. As regard the possibility of transfer the petitioner departmental labor gangs to FSD Changchari is concerned, Mr. Roy has submitted that as per the policy formulated and followed by the respondent FCI, if in a particular depot go down, the work are being done by the departmental laborers, then the laborers of other categories are not engaged in that depot go down, and the same is followed in order to avoid any sense of disparity and hostility. He has submitted that in such view of the matter, since FSD Changchari is managed through the contract laborers, the question of transferring the departmental laborers gangs in which the petitioners are members does not arise. He has further submitted that it is already held by the Honorable Bombay High Court in TIL number 84 of 2014 that departmental laborers can be transferred from one depot to another. The Honorable Supreme Court of India had, by its order dated 31/7/2017, dismissed the special appeal preferred against the judgment and order passed in TIL number 84 of 2014. It is further submitted by him that the transfer order was placed after a detailed workload analysis depot-wise by adopting the criteria that the last gang should be transferred first. He has submitted that in view of the such fact situation, the writ petitioner are devoid of any merits, considering the fact that the transfer is an incidence of service and there are no violations of statutory transfer policy. Paragraph 11. It is an admitted position that the petitioners are departmental laborers in FCI and are part of different departmental labor gangs mentioned above. Main purpose and object of the Contract Labor Act 1970 is to regulate the employment of contract labor in certain establishments and to provide for its abolition in certain circumstances and the matters connected therewith. Section 10 of the Contract Labor Act 1970 has provided that notwithstanding anything contained in the Act, the appropriate government may prohibit by notification in the official gazette employment of the contract labor in any process, operation or other work in any establishment. It transpires that the Government of India issued a number of notifications in respect of various depots of FCI for prohibition of employment of contract laborers under the Contract Labor Act. 4 different systems, that is departmental labor system, contract labor system, direct payment system, and no work, no pay system are in existence for loading, unloading works in food storage depot of FCI located in various parts of the country. Noticing huge disparity in the matter of the payment to the laborers under the above mentioned system, though similarly circumstances and earning of huge incentives by the departmental laborers in clandestine manners, the Nagpur bench of Bombay High Court registered a public litigation being a PIL number 84 of 2014 on its own motion on the basis of a newspaper reported published in the newspaper, The Times of India, wherein it has reported that some of the departmental laborers of FCI were earning to the extent of rupees 4 lakhs per month. During the course of the proceeding of the PIL number 84 of 2004 before Bombay High Court, it came to the notice of the court that there are surplus laborers at various depots of FCI on one hand, And on the other hand, there are deficit levels at some other depot. It was projected on the FCI, on behalf of the FCI, that the attempt to transfer the departmental laborers from one depot to another was resisted by the departmental laborers on the ground that same amounted to change in the condition of service. After considering the report of the experts, a report of a high-level committee, the Bombay High Court was of the view that the government of India ought to have taken necessary steps for denotifying the reports of FCI which were covered under the Section 10 of the Contract Labor Act 1970, which in turn would bring gains management. The division bench of Bombay High Court had also observed that since the transfer is an incidence of service and when wages and all other services conditions of the departmental laborers working at different depots are identical, there was no reason as to why their services would not be transferred from one depot to another. Having considered the entire aspects, PL number 84 of 2001 disposed of by the judgment and order dated 2011-2015 with the following directions. Directions are important, my lord. The Government of India is directed to decide the representation made by the Food Corporation India for grant of exemption under the provision of Section 31 of the State Act within a period of 1 month from today, in the light of observation made by us herein above within a period of 1 month from today. We clarify that the respondent Food Corporation of India would be entitled to transfer the services of departmental laborers from one depot to another, subject to protecting their salary and all other services conditions. We also clarify that the respondent corporation would be at liberty to implement its policy of change in the schemes of incentives. After my lord, paragraph 30, as paragraph 27 of the judgment and audit.
Carry on. Carry on.
Yes, ma'am. Paragraph 27 been quoted here in my lord. We also fail to understand as to why the departmental laborers could not be transferred from one depot to another depot, as could be seen from the judgment of Apex Court in case of the Food Corporation of India Workers Union versus Food Corporation of India and others. And so it was the contention of the said corporation.
In this case, reverse was that. In this case, the departmental worker.
In that case, also all the departmental laborers was there. In this case, also the departmental laborers, and they being the service holder of the FCI, their transfer is the incidence of the service condition. And the exigency, my lord, exigency is that, my lord, because in one
departmental regular employees were time.
In one depot, only one system can work, my lord. One system of labor, my lord. So Shawl having the departmental laborers, so that's why the departmental laborers were transferred, my lord.
Paragraph 2 will distinguish the case. Paragraph 2 of this judgment.
Paragraph 7 also, petitioner the regular employee.
Yes, here also, my lord, the petitioners are regular employees.
Do you know?
This one also, my lord.
Regular employee.
Yes, my lord.
Direct payment system, daily wage worker.
Daily wages, okay.
No, departmental, they are, my lord,
they are departmental workers, but not regular.
System, petitioner are, my lord, direct payment system, my lord. They are regular employees. Out of these 36 petitioner, my lord, 17 have retired, my lord. They are not the wage, only they are not earning the wage. They get salary, my lord. We have annexed with our affidavit in opposition. The petitioner claimed that they are getting only 20,000. That is wrong, my lord. They are getting 60,000, 70,000, 80,000, my lord. We have annexed few of the salary slip, my lord. That is at page 108, my lord. Annexure 11. Net payment, not gross payment, my lord. Net payment is 63,243. Then again on page 109, net payment is 60,553.
Page number?
Page number 108 starts, my lord. Annexure 11. Down below, my lord, there is a net payment 63,243, my lord. After deduction, my lord. After income tax deduction, CPF deduction, 63,243. Next page, my lord, 109. We have given a few illustration, my lord. 60,553. Page 110.
Where are their appointment orders? Or engagement orders? Any appeal against this order?
No, my lord.
No appeal.
No appeal. One paragraph, my lord, my paragraph 60, out page 61. DPS DPS workers are entitled for payment of minimum guaranteed wages for every day for their attendance for work performed by them. In addition to the minimum guaranteed wages, they also get the payment of interim relief at 50 rupees per day and additional payment of the work done by them. This additional payment made to the DPS workers is called incentive, my lord.
Due to incentive.
Where are your the regular employees? There must be an order of engagement.
I can produce it, my lord.
This 108 that you're showing, the
Incentive.
payment that is paid, the pay slip for September
24, my lord.
108.
31st March. Yes, my lord. Retirement date. Retirement date is 31st March 24. At the time of filing the affidavit in opposition, it was filed on 6 February 2023, my lord.
Page 108.
Page 108, Your Lordship, done. Just
This appears to be
incentive earning 62,275.
Start from the top. It says pay slip for September 2020. The pay slip.
They get salary.
Pay slip is to be given to a regular employee. The date of retirement is also mentioned.
Yes,
my.
He might have been retired. Actually, what happened? They are entitled to have the minimum wages. And after completion of certain work, Lord, they are entitled to have incentive. And due to this incentive, their salary, they may get 60,000, 70,000, different things. Lord.
No, this
Now, because of this, only because of this fact, say for example, worker who is DPS system worker,
right to see whether this matter is covered by judgment of the court at bench. Rightly, wrongly, there is a judgment of the court at bench. It's similar matter, where the petitioners are treated the employees of FCI and then transferred being an incident of their court decline. Now,
no.
the only thing is that they're not regular.
Only thing is that if your lordship comes to paragraph 22,
yes,
they are regular employees.
Correct.
They are regular employees. Here they are not regular employees.
We wanted the engagement order or some document to show how you are engaged with the
No, that is not required. If you go to the paragraph annexer C, they are ancillary work, annexer C.
Yes.
Those workers who are not regular employee, they are called as ancillary employee.
See, you are being given a pay slip. You are being given a pay slip. There is a pay slip. Even in your documents, you have enclosed pay slip. Annexer AC.
Yes.
So there is an employee number also indicated.
Yes.
So there must be some document to show how you are engaged with the certain, some order, some document to determine whether you are regular employees or.
No, that is probably clear from this judgment itself. The judgment.
I can produce it, my lord. Can be.
Judgment itself, there it is indicated that there are 4 categories of pension. Just now, my learned friend read it out. What is the paragraph number? I cannot say right now.
That is the paragraph only.
That is paragraph 2 only in my paper. And he has read
paragraph 11.
Paragraph 11, no? All right. It is an admitted position. The petitioners are departmental level in FCI and are a part of the department mentioned above. The main purport of the object of the contract labor regulation is not regulation. Yes, contract labor system for different system. Just the bottom. In respect of very FCI prohibition implies the contract laborers under contract labor agreement for different system. Departmental laborers, DLS, contract laborer system, direct payment system. We are direct payment system. Direct payment system and no work, no pay system are in existence for loading and unloading work of the food storage farm. Except contract labor regulation, contract labor, there are all are departmental workers. DPS.
What is your status? If you are trying to interpret it from judgment, but like some documents that you have like employed
I have to refer the standing order. They have their own set.
we go into everything, but first, how you are engaged? There must be some order from the FCI saying that you are direct payment system.
It is not denied that we are not the direct payment system market. They are in
So
their
if
affidavit also.
their claim that direct payment system is also
Yes,
departmental.
their concern is, my concern is same. Direct payment system workers are also departmental workers. You want worker, that is the problem. Departmental workers, but they are not the regular employees. But these direct payment employees, DPS workers are protected to the extent that they should not be transferred more than 100 kilometers away. But due to certain exigencies, they can be transferred.
Where is that circular 9 of 2016? Or 9 2016.
2009. Page 30, right?
30 is circular 11. Clause number 1, they refer to circular 9 of
2016. Albania.
Already, it is at page 100 of my affidavit in opposition.
Page 100. Or 101?
Annexure 5. So, para 3 and 4 is important. The sifting pooling exercise is to be undertaken as per the direction of the Honorable High Court of Bombay to make the operation more efficient and cost effective. The direction of the High Court to the effect that the salary, wages, and other service conditions of the workers will not be disturbed while undertaking transfer of these workers must be meticulously complied with. The Honorable Minister Swenso has observed that in certain places workers are being shifted to far-flung areas and it has been desired not to shift the workers beyond 100 kilometers unless in case of extreme exigency or in a situation where the workers inevitably have to be transferred out of the region. So there is no direct power, my lord, only in case of the exigency. Here the exigency is that, my lord, only departmental labor system is working at Tolkwa.
Not only exigencies, extreme exigencies.
Yes, my lord, extreme exigency.
How it can be?
And in one particular FSA, two system of workers cannot work, my lord. Otherwise there will be a pay disparity and other situation, my lord. So
Team exigencies. Because they have to pay more to the contract laborer.
What is the meaning of exigency and extreme exigency in the FCI part? What is the judgment of the Nagpur bench of the Bombay High Court?
Yes, we have annexed, my lord. Start from page page 69. This PIL was taken two moto, my lord. The newspaper when the departmental labor system was earning more than 4 lakhs, one particular asset.
Then paragraph 13 is the direction, no? 93. Paragraph 30.
My lord may come to paragraph 23, page 87 of that judgment.
Paragraph
At the cost of repetition, page 87. Para 23, page 87. At the cost of repetition, we make it clear that we are not against the laborers getting handsome wages and incentives. However, at the same time, the situation which permits glaring disparities cannot be permitted to exist. On one hand, there are persons doing similar work getting 10,000 per month, and on the other hand, there are 370 laborers working with the same corporation doing the same work who are getting an amount of rupees 4 lakhs per month. As already stated herein above, we would be happy if every laborer in this country gets a salary of rupees 4 lakhs or more. However, it is ground reality that for the same work, one person gets an amount of rupees 4 lakhs and another person gets an amount of rupees 8,000 or 10,000 per month. We find that such a position would also be a violation of constitutional mandate. In a salary which one person gets in an amount of rupees 4 lakh, 40 such other persons can be accommodated in a country facing large scale unemployment, and the families of such 40 persons can be maintained in that amount. It will not be out of place to refer to Article 38 of the Constitution of India. The Article 38 mandates that the state to strive to minimize the inequality in income. The present situation permit a huge differences in wages to be paid or two sets of employees doing the same work. So, my lord, the exigency herein is that in Tawalkwa, that departmental labor system is working. There are now few laborers there, my lord. We want to pull up that laborers from the Tihu. Already the departmental labor system from the Gosaigaon FSB has been transferred there, and they have happily gone there and joined their service. Only the Tihu FSD, my lord, they have filed this writ petition. Otherwise, they have earlier raised the labor dispute matter before the labor commissioner, where they have stopped raising their objection there, and thereafter the ex parte order was passed, my lord. And after having there was an order of ex parte, my lord, they approached this honorable court and obtained the stay, my lord, on the ground that they cannot be transferred beyond 100 kilometers. So I would like to rely on other circulars, annexed to page 95.
reference the clause.
My lord, at page 95.
Page 100.
It's circular 9 of 2000. According to that clauses, the exigency, my lord, we have stated in our paragraph 49 at page 56. My lord.
Have stated exist, but you have justified that clause the extreme
Exigency in the sense that, my lord,
you are trying to balance the labor on the point of incentive or
no, not exactly, my lord, as said by my petitioner, my learned friend, my senior friend. Actually, we want to rationalize pulling of the laborers in one FSD, one system of workers should work, my lord. Otherwise, there will be a disparity in the sense that there will be a promotion between all the different types of laborers, my lord. Because the contract laborers will not allow the DPS workers to earn more, and even the DPS workers will not allow the contract laborers to get more work. That's why, my lord, the parity in one FSD, that one system should work, my lord. Since all for there is a DPS, only DPS system is working, my lord. Direct payment system is working. So we want to transfer all the from other three DPS, my lord, FSD, my lord, the DPS laborer to the Chaulkwa. Gosaigaon, my lord, and they have been transferred, my lord. They have already joined. Only in regard to the PU FSD, my lord, they have not joined, my lord. They have, because of this present writ petition, my lord. The stay there is a stay, my lord.
Lord, PU is not true. Not a case that work go and up. Whatever or you are shifting it that if group of laborers were working there, you are thinking to transfer them and replace them instead of what's the
We want that only one system of labor should work in a one particular FSD, my lord. My lord, my paragraph 49, my lord, at page 56. 49, 59. Would rely only three paragraphs, my lord, of my affidavit in opposition. Para 49, that as on March 2022, DPS workers were manning 4 depots in Assam region, namely FSD Bindupuri, FSD Chaulkwa, FSD Gosaigaon, and FSD Tihu. The number of workers working in the respective depots were less than they required as per the prescribed sanction strength, resulting into problems in operation at the respective depots.
where is the decision? Where is the decision that the case where it fits into the requirement of extreme urgency in terms of circular? Circular is the intra-department circular by FBI. It's the circular 9 by Gentleman. Where is the impute order?
Impute order is that, my lord.
Page 29, no?
9.
Of writ petition. All gangs of DPS laborers, including
May I read it, madam, from the first beginning. In order to ensure compliance of the direction of FCI headquarters New Delhi, FCI Jadot and Guwahati to rationalize the labor system for its optimum utilization, it is decided to transfer the DPS labor as under. All gangs of DPS laborers
including all ancillary laborers, handling laborers, sardars and mandals of FSD Gosaigaon under DO Koprajar and FSD Tihu under DO Guwahati are hereby transferred and posted to FSD Chalkwa under DO Dibrugarh with immediate effect and until further orders based on the operational requirement and also to reduce the OTA incentive being paid. The workers are being transferred with the stipulation that their salaries and other service conditions shall be fully protected, for which guidelines have already been issued by the FCI so letter dated 7/12/2015 and 12/7/2016. Transfer benefits and joining time will be admissible as per the rules applicable to them. All the workers who have been transferred by the transfer order are advised to report for work at their new place of posting immediately. From this order also it depicts, my lord, that they are the salaried person, my lord. And transfer being the incidence of the service, my lord.
Right. So that's saying that not beyond 100 kilometers.
In case
So
of
you-
in
I think
case
you
of
should be-
exigency, my lord, but the exigency is that we want to rationalize one type of workers.
Was your order, department order. There must somebody decide that these workers are not able to carry on work, the external labor.
There are committee reports which we have not annexed. We will take leave of this honorable court to produce on Tuesday, ma'am, which we have stated in our paragraph 51, my lord. The constituted committee examined the issue taking into consideration the sanction strength vis-a-vis man in position of the DPS worker, handling cost per MT, retirement profile and cost savings after rationalization. The committee noticed that there is a shortage in all the 4 depots in Assam region. However, huge shortage was noticed in FSD Chalkwa. Accordingly, after considering all factors, the committee, by its report dated 21/3/2022, concluded that the existing laborers at FSD Gosaigaon and FSD TU may be transferred to FSD Chalkwa. And I will produce this committee report 21/3/2022 if your lordship will allow me. So based on this committee report, my lord, this decision was taken. Again, in next paragraph 52, that the committee report was processed and in the meantime a letter dated 8/3/2022 was received from FCI headquarters wherein reference was invited to FCI headquarters circular number 9 of 2016. That 100 kilometer unless in case of extreme exigency. While examining the committee report, it was observed that none of the depot of Assam region where DPS laborers were working were within 100 kilometers, and further, the rationalization of DPS laborers in the region was necessary due to huge shortage of laborers in some depots, due to which labor earnings also shot up beyond 1 lakh. And also in case of the FSD Chalkwa, the operational difficulties were also observed.
Whether this circular was considered in the earlier judgment.
I think, my lord, it was considered, it was stated that this circular was not challenged, my lord. Their observation in the earlier judgment. At para 25 of the transfer affected by the imping office 25. The transfers affected by the imping office order dated 12/8/2020 are in the nature of inter-region transfer. The imping order has been shown to be passed by the respondent number 2 with the approval of the competent authority. No challenge is laid by the petitioners to the effect that the imping order has been passed by the authority not competent to pass the order. There is even no challenge in respect of the rating the policy of the transfer formulated by the respondent FCI by this circular dated 12/7/2003.
Precisely what they are doing.
There is no check.
No.
From the
Saying that
discussion
the
made at above, it is found that there is neither mala fide exercise of the power of
They to tell it. They are taking the benefit of this. They are saying that this dispute order.
no, from the paragraph, my lord, which I have read out, my lord, my affidavit over that is the exigency, my lord. There are 49, 50, and 51, my lord. It says about the committee, my lord, which was constituted and their report dated 21/3/2022.
Right, we are passing order.
If need be, my lord, this committee report I can hand over to the court master, my lord, tomorrow, 21/3/2022.
What?
I will hand it over.
The ground, if you're justifying your actions only on the ground that some committee report is there, but without any explanation as to what is the status of the circular, that's the identified. It's an intra-departmental circular. One officer saying one thing, another officer saying another thing. Where is the good? Yes. We're allowing the repetition. We're allowing the repetition to pass.
Right.
Lordship, here the pleadings are complete, Lordship. We have also filed a affidavit in reply. However, Lordship, we have to obtain specific instruction as regards the arrear salary, whether it has been released to the petitioner or not. And it's not quite so. Lordship. That stand is not clear in our affidavit filed by the respondent.
How much time do you require?
2 weeks, Lordship.
Right.
Lordship may fix the matter after vacation.
Yes. The respondent will also apprise the court whether the area standard period 23/06 of the 9/28 of the as in the meantime. They start this record.
And you.
I'm for the counter general.
Item 7.
Maybe like, kindly fix at 2 p.m. At 2 p.m. kindly fix.
Yeah.
Keep the
Item number 10.
Respondent number 4 and 5, my lord, I am appearing for the first time today. I may be given.
How much time? Don't even have a copy.
That's now
We had taken regular post. We had served by AD. We have also sent them by post. We have filed an FAR. We have served them through
Now
email.
when the council appears, why don't you extend the courtesy of
No, we'll give them, Lordship. We have already served. We have already filed an affidavit to that effect also.
All right.
We served him also. It's not an issue. He's just appearing today.
You want
I want some time to file affidavit.
for
On behalf of
4 and 5.
4 and let's take a hearing on behalf of the You have received instruction.
No, I got only, my lord, information to get to
That
APR.
you'd like to complete the instruction. Madam, it's good. Yeah, after 6 weeks.
But if there is an interim order, okay, that may be.
That's order passed earlier will continue until further.
Right.
Right, Peter. In this case, owner has been given a retirement for animation compulsorily on the ground that he has attained the age of 60 years, while in fact he has not attained the age. That is the issue. Lord.
My lord, kindly see last order, my lord.
Yes. Where is the government advocate? You're
Lordship,
supposed to produce some record.
Lordship, the records are not received yet, Lordship.
What records we call for? Relevant record. That would be your what? Service book.
Service, another.
You are representing
Explorer 5, my lord.
which 5?
Private respondent, my lord. Newly appointed, my lord.
Why are you? What's your grievance against private response 5?
No, in the meantime,
My
he,
lord,
was, he has been
already
selected for the post to which
issued
I have.
advertisement and interval was already held, my lord. In the meantime, appointed me.
When did you realize that your date of birth is wrong?
No, when I have been given compulsory retirement, there is it is not their case.
When were you given compulsory retirement?
On 31/5/2022. So they did not give me this order. I was not getting salary. So I approached the authority that I am not getting salary. Thereafter, they informed that you have been compulsory retired, even though I am working still 8 years without salary.
Where is that order of compulsory retirement?
Lordship will get that one at page number 27. By way of this order, a large number of candidates have been given repair.
Your name appears that.
Lordship will get at page number 29, serial number 30. This is, he was a helper in a Anganwadi center.
When can you get the report?
After vacation, Lordship, any date may be fixed.
It's okay. Second week of August.
For vacation year, it's possible to they are only produce the service record here.
Before vacation, not yeah. Also August. Maybe they be responsible for meeting, training, service book, other relevant right name, date of birth.
Obliged.
Lordship, I am for the respondent number 10, Lordship, private respondent. I need some time, my lord, to file affidavit, my lord. Opposition.
Actually, on last occasion, when it was listed 5th of March. Since then, it's been almost 3 months. Lordship, private respondent has not
You were
given.
given time to file affidavit. Why you did not file?
Okay.
So March.
Respondent number 10. Her phone number is changed, Lordship. Therefore, I could not contact.
It's been more than.
Now, have you been able to contact?
Lordship,
Have you been able to contact the respondent 10?
Yes.
Have you received your instruction?
Earlier, before this, at the time of filing the Okalatama, Lordship,
some information received.
You are now praying for type 5 affidavit.
Affidavit, Lord.
Have you received instructions to file affidavit?
No, Lord.
Then how will you file?
I will contact. Only 1 week time maybe.
Who's the first wife here?
I'm the first wife.
You're the first wife.
Eldest with your lordship.
Now who? Respondent Ted is receiving salary.
No lordship.
The pension.
No lordship. Pension is as per order of this honorable court. Pension is as of now state.
He is on interim, Lord.
Lordship, actually, we right after the death of my husband, we have got some information that respondent number 10 was trying to siphon off the pension through some coherent means. That is well, Lordship. But we have urgency for the matter to get adjudicated. It's been more than around 1 year since my husband's death. The private respondent number 10
Where is your next of kin?
Lordship.
Page number 56.
Yes, Lordship.
Who is the first wife here?
Serial number 2, Lordship.
Here shown as the second wife.
No, Lordship. Actually, that is because age-wise, I am younger, but I was married first.
Where are your documents? Justify that.
We have enclosed the Kavinnama, Lordship. May peruse page number 34, Lordship. NHA 1.
You accept that respondent Ted is also a wife.
Yes, Lordship. Husband
Married for the second time.
Yes.
And what is your instruction?
Lordship, Sir Kabil Nama, he is Jahanara Begum, not Jahanara Ahmed.
Are you disputing that she is the wife?
As per information, my Lord, the respondent number 10 never made the petition, Lordship, in her life. The petition also annexed, my Lord, one LIC copy, Lordship, page number 63. That is, that page, nominee is respondent number 10, Lord.
We can make an attempt to send you to mediation, sort out your difference. Otherwise, it becomes a disputed question of fact.
No, but otherwise, as the full bench
Full bench judgment is there, provided you are a wife. If the dispute the very the question of your marriage, the full bench judgment will not be applicable.
our documents acknowledge that fact. Legally married first wife and eldest widow. That name, Lordship, that is not. I mean, due to some, we can produce also documents that it is the same person. Lordship. In fact, you have. Lordship may peruse page number 37, Lordship. Yeah?
You expressed urgency, therefore we thought you can sort it out. If both of you agree that yes, you are the wives of the state employee, then full bench judgment can be used.
Lordship can kindly peruse Lordship peruse page number 37, Lordship.
37.
The allegation which my learned friend has raised is addressed in this document, Lord. Is the same person, Lord.
That affidavit shown after death of her husband, Lord.
If she is disputing your marriage,
Them, let this honorable court adjudicate the matter.
why should we adjudicate? You go and fight. Why should we adjudicate on this issue? Who is the first wife, who is the second wife?
But we have other relevant documents.
Yes, you file your affidavit after 3 weeks.
Finally, a date it takes
Let him file affidavit after 3.
Yeah.
Yeah.
This matter is relating to suspension from service. The order was not reviewed. I filed a petition. Subsequently, Lordship, they have reviewed the order for 90 days. Now, the sole issue is to be determined whether the
Departmental proceeding not
initiated.
initiated.
Yes. Department proceeding. But they did not review the order within the period of 90 days.
Because the judgment.
Yes, Lordship. There is a division bench judgment of our High Court, Lordship. But the issue was in this case, Lordship, the review was not done within a period of 90 days. That has been reflected in para 1. And relevant is at para 12 and 13. May I read? In Lordship, this is Ojit Sonal.
Paragraph?
Para 12 and 13. In the case of so-and-so, the apex court had interpreted sub-rule so-and-so of rule so-and-so and held that an order of suspension would not survive after the period of 90 days unless it was extended after review. In that case, it was observed that since no review was held within a period of 90 days, nor was there any order of extension of the suspension issued within the said period, subsequent review and extension of the order suspension would not sustain the order which had already become invalid after expiry of 90 days from the date of suspension. From careful analysis of the above decision of the Honorable Supreme Court, what follows is that unless the review is held within 90 days, an order of suspension, including one issued due to the detention of an employee in custody for 48 hours, would not survive, nor can such an order be granted fresh lease of life by carrying out a review after expiry of the period of 90 days. In view of the law laid down so-and-so, supra, it is axiomatic that the order of suspension dated so-and-so had lapsed after the expiry of 90 days due to want of review of the same by the disciplinary authority. We therefore find ourselves in agreement with the finding recorded by the learned single judge in the judgment and the order dated so-and-so. So that the order of the learned single judge has been upheld by this court. The learned single judge order was that review was done after a period of 90 days, so that is not.
Where is your suspension order here?
Yes, Lordship. Suspension order, your Lordship will find at page 26.
It is on 14th December.
26.
It's 14th December. 14th December.
Yes, Lordship. 14 December with effect from 10/12/2023. That is the date of arrest. And 90 days will has expired on 10th of March 2024. 10th of March 2024. And Lordship, page 46, this is the review order that they have annexed in the affidavit. That was also not supplied to the petition. Your Lordship, kindly come to page 46, running page 46. Suspension order was issued on 14/12/23.
So where is that order? Order? Review order?
A review order page 46, running page.
46. 46 is the part of the affidavit.
Yes, part of the affidavit.
Where is that order?
My lord.
Where is that order? Copy of the order.
Yes, copy of order, page 46.
46 is the part of the affidavit. Yeah.
Yes. They have, Lordship, for the first time, Lordship, they have annexed the.
Am I not audible or something? Are you not able to hear me? I am asking you, where is the copy of that order?
Order of
Review.
Review, that is page 46.
Not 46.
Running page. Affidavit filed by the respondent on 26th 2025, dated 20 June 2024.
What is the date of the order?
26 2024. 20. This affidavit was filed, two affidavit filed, Lordship. This affidavit was filed on 26/3/2025.
Filed by respondent number 3.
Filed by respondent number 3.
3.
Deputy. And this is the first order, and second order, Lordship, page 47. Review order.
It is not here. 20 June is not here.
My question is that, Lordship, this review was done after the period of 90 days. This review order has, Lordship, has no force at all because it is beyond 90 days.
What is the name of the petitioner? Name of the petitioner?
Date?
Name of the petitioner?
Sudhir Kumar Pal.
In the affidavit, it is not enclosed. Annexure 1 is 27 May, then 6th of June, and then 14 June. That's all. These are the 3 orders. Additional affidavit.
Additional, yes, Lordship, additional 2 orders. Yes, 3 orders. One is 20 June 2024. Second one is 2nd September 24. And third one is 10 December 24.
Yes, madam, what do you say?
Lordship.
Division bench judgment.
Lordship, there are other judgments also there, and because the show cause has been issued within the period of 90 days, Lordship, and thereafter, as per 20th February,
Go through the judgment.
Lordship, I will go through, Lordship.
We'll come back.
Yes, Lordship.
We'll come back. Did you see the judgment? Yes.
Lordship, I have emailed 2 judgments, Lordship.
Of this court?
Yes, Lordship.
Division bench?
No, Lordship, both are single bench, but this division bench matter has been discussed there, Lord.
Are you placing this judgment saying that it disagrees with the division bench? No.
Not, but the suspension that Lordship is pointing that the allegation of the petitioner that within 90 days period Lordship judgment suspension order has not been reviewed. And there is also one OM of the issued by the Personnel Department of the State of Assam Lordship. I also have emailed the copy. Lordship. Oh. Where Lordship, if the charge sheet, Lordship Chokos is filed within the period of 90 days, Lordship, in that case, Lordship, there is no mandatory provision that within 6 months, the next has to be reviewed, Lord. This is there.
No, here there was no show cause.
Yes, Lordship. It is there. Yes, yes. It is there.
When?
Page 32, 1/3/2024.
It was within 90 days, Lordship.
Within 90 days.
Yes, Lordship.
What is the stage of the TP?
TP is completed, Lordship.
Completed.
Yes, Lordship.
Then why are you keeping him in suspense?
Lordship, now, because the petitioner is under the administrative control of the no, revenue, it has been sent to the revenue department. Lordship, in paragraph 8 of our affidavit in opposition, we have stated, Lordship. The deponent begs to state that the departmental proceeding initiated through order number so-and-so dated 6/2024 was meticulously conducted and subsequently forwarded to the Principal Secretary of the Government of Assam Revenue and DM Department on 21/8/2024, Lordship, in compliance to government letter number so-and-so. The delay in the, so this is there, Lordship. And the cause of delay is their Lok Sabha election and all these things. This has been mentioned, Lord.
What TP is there within 90 days then? Where is the further requirement?
No,
It cannot be.
they are saying from long back that DP is in the.
So we'll close it by giving them a direction to pass necessary orders within
Lordship.
3 weeks.
Lordship, yes,
Within 3
Lordship.
weeks
Yes.
from today.
Yes.
The law is very clear that Lordship, there is another judgment in Mirgan Kulita, your Lordship was there. This is the division bench order.
But this memorandum is also there. Official.
Yes, Lordship.
Yes. That
This
is also
court.
Lordship in.
This is in court.
That is also beyond the 60 days, another 90 days. So 6 months, after 6 months.
After 6 months.
Yes.
After 6 months. Here, when was the review made?
20th, 2006/24, Lordship.
2006/20.
Yes, Lord.
So another 92 days.
Then 2nd September.
The reason
Yes.
reason is explained, Lordship, in paragraph 8.
Is there anything to show that departmental proceeding has been completed?
Yes, Lordship, we have stated in our affidavit. It has been forwarded to the Revenue and DM Department, Lordship.
Paragraph?
So there, in paragraph 8 of our affidavit in opposition, Lordship.
Date is also not given when it was forwarded.
Yes, it's there, Lordship.
Thereafter also, Lordship, this affidavit was filed on
I think he has
5/2.
not gone through the affidavit, Lordship. All the dates are here, Lordship.
This affidavit was filed on 5/2/25.
If he has to counter, he has not filed any reply to that also, Lordship. So whatever is there in the affidavit, Lordship.
These are on
there.
record. I'm not submitting beyond the record.
In another judgment,
We'll
Lord.
dispose it off with a direction that you conclude
This
the DP and
specific time
orders within 3 weeks.
Lordship.
Within 3 weeks.
Yes, the final outcome has to be
That to be, and also on the suspension.
Yes, Lordship.
In the event, Lordship, no order is passed, then he may be allowed to reinstate in circuit.
That will include.
Yes, Lordship.
Within 3 weeks, if not there, then
Lordship.
without report to this court, he'll be reinstated in service.
Okay.
Lord. We'll pass order.
Lordship.
Yes.
I have gone through the order, Lordship, but here fact is little different. Here, Lordship, in the judgment, the wife of the deceased, she applied Lordship within a time frame.
Yes. Yes.
And in the due process, Lordship, the son, he became, attained majority Lordship, subsequently he applied. So this is the case of that. But here, admittedly, Lordship, they waited.
Who's the petitioner?
Here the son is the petitioner, Lordship.
You applied after majority.
Yes.
Yes, Lordship.
And Santo?
Lordship, initially my brother applied. So he was not physically fit, and thereafter I applied. And representation
After
was
how
going
many years? After how many years of death?
Lordship, he died in the year 2009, Lordship. And subsequently, I have applied when I attained the age of majority.
Which year?
I applied in the year, Lordship, I attained in the year 2019 because higher secondary certificate, which I have annexed, Lordship.
After 10 years.
Yes, Lordship. Lordship, I just want to rely because just one chance, because it's up to them, Lordship. Let them decide. If they reject, then that's for all, Lordship. Just I want to rely upon this.
Is there any notification that after N. Santo's judgment?
Lordship, yeah, I'll also like to.
What is the last notification? 2015.
2015, and this 2015 is not applicable to them, Lordship, as per NC Santos.
That's what I'm saying.
Yes, Lordship. This is
so
there.
Is some notification there after that?
No, Lordship. Subsequently, Lordship, the notification regarding the compassionate family pension and all this has been stopped, Lordship.
2024, there was one notification, Lordship, and that was challenged in WPC. Yes.
19, that 18-9.
Yes.
Yes.
18-9.
Yes.
Yeah. Yes.
Lordship, this will not
and
also,
there are, because when this order was passed, this writ petition was pending, Lordship. I just want a sympathetic view, just to one chance, Lordship, and that up to definitely up to the authorities. If they reject, also I will not come. But just one consideration, Lordship.
So if they consider to close it, but we can't issue a direction to them.
Yes, Lordship.
Because you have to establish your right.
Lordship.
What is your right? If you
Understood, Lordship. Is a compassionate appointment.
Right, but compassionate appointment can't go on and on and on forever. There's some
The-
parameters.
This Devabha Tiwari
how you
will come,
will
Lord.
survive
Lordship,
5 years.
but in this case, which I would like to rely upon, if
This is the
Lordship,
case where marriage were not custom, only on the ground that you're referring to the court-made judgment or recent court-made judgment.
and this based on that judgment, another order was recently passed, Lordship, on 34/2025, Lordship.
This one, what I'm telling, Lordship. This is
coordinate
little different, Lordship. This. Because this was the wife of the deceased applied on time, Lordship. And subsequently, the son attained majority. Here, Lordship, admittedly, they have not applied, Lordship. So this is the difference, Lordship. It cannot be.
Lordship, initially I have stated also, brother
Your
had
case
applied.
is rejected by DLC.
Yes, Lord.
Yes,
Rejected.
Yes,
By
Lordship.
DLC.
Minutes, but I have not been communicated this minute to somebody else. I got it. It was not rejection. This thing it was not. So this is the reason I have challenged the part of that DLC.
Where is that DLC?
DLC it's at page 42, Lordship. Minute, Lordship. Initially, it was forwarded, Lordship, annexure 3, Lordship,
As
page
per
22.
OM dated June 15, when is it required to be furnished? When is it required to be submitted? Within 1 year?
1 year, Lordship.
1 year.
Lordship, initially, Lordship.
2010, it is 1 year, Lordship.
Yes, yes. We can dismiss or you can withdraw. Up to you.
Lordship, page 22, Lordship. Just Lordship, based on the coordinate bench judgment, if one chance is given, it's not that I'll get the job. It's their consideration.
No, but you are asking for something which is not permissible under the existing rules.
Then Lordship, just give me next week, let this matter be fixed. I will satisfy Lordship on that.
Well, we can't stop you from being optimistic. Yes, list on next week. When do you want it? 18?
Yes, Lordship, next Friday.
Next Friday?
Yes, Lordship.
20. All right.
Yes.
List on 20 at the request of
Deeply applied.
Yeah.
MSF particular.
May I please, Lordship? Lordship, my senior M.E. Mahmood Lordship lakes on another court, Lordship.
Matter will listed next week. The request of
Lord, but date may fix, Lordship. And date may fix, Lordship.
next week it will come. Some date will begin.
Deeply applied.
With M. Bhattacharya and R. Bo.
Yes. Well, a very short point of law is involved in this case. The petitioner before Lordship, my lord, he is an ACS officer. Currently, he is in the rank of additional secretary. Now, he is, my lord, awaiting his nomination to IS. Now, what had happened, my lord, Handloom and Textile Department, under the director, made some recruitment. In that recruitment process, allegedly, there were some irregularities. And petitioner, as a joint secretary of Handloom and Textile Department, he was entrusted with the inquiry. Now he submitted an inquiry report, and that inquiry report was not to the liking of the government. Therefore, a disciplinary proceeding was initiated against him. And this, my lord, complaint, it was an anonymous complaint. Lordship knows under the CVC guideline, an anonymous complaint cannot form basis for initiating a departmental proceeding. And my lord, when the terms of reference of that inquiry was, the senior most secretary of the department will look into the matter, then only it will be referred to the government. Now, apparently, my lord, I am not involved in that recruitment process. Now, if the lordship should kindly come to that inquiry thing, my lord, at page 56. Now, this is the report which was submitted. I'm sorry, Malat, I must place that order instituting the inquiry. I'm sorry, one second. Sir. Yes, I'm sorry, my lord. Lordship will kindly come to page number 28. Yes. An anonymous complaint was submitted before the CM Secretariat, and CM Secretariat, my lord, forwarded it. I am directed to enclose herewith a copy of the letter dated addressed to the Honorable Chief Minister, along with its enclosure, wherein the following has been inter alia alleged. The then FAO of Directorate of Handloom and Textile did not sign the minutes of selection committee meeting held on 2919 in spite of being present as a member in the selection committee. A subcommittee was constituted by the then Director of Handloom and Textile regarding filling up of the post of master weavers by overruling the selection committee approved by the government. In the notification issued by the then director, the subcommittee for selection of master weaver is shown to be formed as per decision of the meeting of the committee held on 2919, but in minutes of this meeting no such decision was taken. The subcommittee entrusted Messrs. Okomi Enterprise, a private firm, to print question paper for examination instead of government press. Practical test for selection of master weaver was called by the director without declaring result of the written test, and no meeting of the government approved selection committee was held for shortlisting of the candidates after the written test. Some selected candidates of 20 years of age submitted experience certificate of 10 years. That is, she had involved in training at the age of etc. So this has the approval of the Chief Minister. So this was an anonymous complaint, my lord, which was forwarded by CM Secretariat to the Handloom and Textile Department. Now the anonymous complaint is at page 30, my lord. If your lordship would kindly come to page number 35. Kindly see, my lord. It's an anonymous one, pseudonymous. Now, based on this, now if your lordship would kindly come to page 39. I'm sorry, not 39. Page 41. In pursuance of letter dated 13/5/22, Hari Prasad Bora, that is the petitioner, assist ACA Joint Secretary to the Government of Assam Handloom and Textile, Sericulture Department is hereby appointed as an inquiry officer to inquire into the allegation of irregularities in selection and appointment of 6 master weavers under the Directorate of Handloom and Textile during the period so and so. Further, SP Bora, Joint Secretary, Government of Assam Handloom and Textile, is required to inquire into the matter thoroughly with a request to submit a concrete report within 15 days. Then, my lord, an inquiry was conducted, and my lord, the report was submitted. Now, inquiry report is at page 55, my lord. Inquiry report into the allegation of irregularities in selection and appointment of 6 master weavers under the Directorate of Handloom and Textile. D.J. Das, the then FAO of the Directorate, was present in the meeting of the selection committee held on so and signed the minute. As such, allegation of not signing the minute in spite of being present in the meeting of selection committee is not based on facts. Constitution of subcommittee by the then Director Handloom and Textile for filling up the post of master weaver by overruling the selection committee approved by the government is not based on fact. The selection committee in its meeting held on 2/9/19 had requested chairman of the committee for setting up the question papers for interview written tests. The then director, for her convenience, constituted the subcommittee at her discretion to keep the process confidential and to prevent any leakage of question paper. The then director and chairman of the selection committee, on being requested by the selection committee in its meeting dated 2/9/19, may fail for constitution of a subcommittee at her discretion to get assistance and advice from other two members during the process of setting up question papers and to get the process completed is confined. Ahomi Enterprise was empaneled printer of Director of Handloom and Textile. Firm has carried out different printing assignment of the director taskfully in various occasions. Realizing the confidentiality of the matter of printing question paper, the subcommittee decided to engage Ahomi Enterprise for the task of printing. The post of master weaver needs skill and should be sound in practical work. A candidate who performs good in written test may not be at home in practical, or a candidate who is sound in practical may not perform good in written test. So it was felt to give chance to all candidates to appear in the practical test. Purpose behind decision was only for selection of candidates having balance in written and practical. The minimum age of candidate for the post of master weaver was 18 years as on 1/1/19 as per the advertisement. Prior to publication, approval of advertisement was received from the government. Accordingly, the scrutiny committee recommended only those candidates in connection with the recruitment examination who possess minimum 18 years as on 1/1/29. My lord, I have placed the report of the inquiry just to appreciate even on merit, my lord. I don't think there is anything else. Now, after this report was submitted, my lord, what they did, they issued a show cause notice at page number 59. You are hereby required to show cause under Rule 9 of the Assam Services Discipline Appeal Rule, read with Article 10(11) of the Constitution, why any of the penalties prescribed in Rule 7 of the aforesaid rule should not be inflicted on you on the following charges based on statement of allegation. Now, number one, that a complaint has been received by the government regarding the irregularities and illegalities committed, as I have already pointed out, my lord. Then two, based on report of the then secretary, the following false, incorrect, misleading facts were found in your inquiry report. So, my lord, these were the, according to them, these were the infirmities which were noticed in the inquiry report. Therefore, the charge is the inquiry report was not, to the liking of the authority. Now, my lord, if we go by the normal practice in the service jurisprudence, if an inquiry officer's report is something where a further inquiry is required, then the disciplinary authority can always say that I disagree with your report.
This is not a Rule 9.
It's a Rule 9.
It's
a Rule 9. It's a Rule 9 notice.
55?
Page 59, Miller.
No, 55 is preliminary inquiry.
Oh, yes, yes. I was trying to draw your lordship's attention to page 59.
No,
59 is a Rule 9 show cause.
You're saying that inquiry not being to the liking of the authorities
Yes.
initiated this.
Yes.
So this inquiry not being liking means the preliminary inquiry.
No, this inquiry.
Okay.
The inquiry, my lord, no, what I'm saying is, page 59 is the show cause. Then, my lord, my reply starts at page number 66. I have denied all this. Then, my lord, the inquiry report was forwarded to me at page 101. With reference to I'm directed to enclose here a copy of the inquiry report. So in terms of my lord Ramzan Khan and all, so my lord inquiry report was forwarded to me. Then I submitted my explanation also. Then my lord, an order of penalty was passed at page 117.
No, what was the finding of the inquiry?
Yes. No, my lord, I was trying to address your lordship on a slightly different tangent, my lord. What I'm trying to say is, now, as far as this recruitment process is concerned, I was not involved. I was tasked with the duty of making an inquiry into the anonymous complaint. Therefore, my first articulation is, my lord, anonymous complaint cannot be the basis for any disciplinary act. That is my first point. There is a judgment of our High Court also. So this complaint, which was submitted before the CM's office, that could not have formed basis for initiating a proceeding against. CBC clearly says no, it's not permissible. Now, secondly, I read the report of the inquiry to show that even on merits, the perception is wrong. Thirdly, my lord, if the inquiry officer, according to the disciplinary authority, there are some infirmities, then, my lord, under the Rule 9, he can always direct a fresh inquiry by the same inquiry officer. Further inquiry. Or, my lord, disciplinary authority may say, sorry, I don't agree with you on these reasons, I disagree with your finding. Then with the reasoning, it should be given to the delinquents, not me, those delinquents. But where is the scope? End of the day, my lord, if I do not perform my duty diligently, it's not a misconduct. Somebody may be very efficient, somebody may not be. How can it attract a disciplinary action, my lord? Unless you can show that there is some collusion with somebody else. I may have not lived up to the expectation of the authority. And no, most importantly, my lord, this inquiry report which I did, it was supposed to be, my lord, supervised by my principal secretary. And the recruitment was done by director. And what have you done to these illegal, so-called illegal appointees? So therefore...
We're not a part of the...
No.
We're only asked to make an inquiry.
Inquiry. I did the inquiry, I submitted the report. If that inquiry, according to the disciplinary authority, was not according to, what should have been, then he could have disagreed. But where is this scope to, my lord, proceed against me departmentally on the premise that I have committed a misconduct?
Where is the show cause again?
Yes. Show cause is at page 59. And listen, my lord, that a complaint has been received by the government of Assam regarding irregularities and illegalities committed in selection and appointment of 6 number of master weavers under the Directorate of Handloom and Textile, and you being ordered by the government of Assam to inquire into the matter and submit a report, you submitted a report white letter dated so and gave a clean sheet to the recruitment process, which being misleading and factually incorrect, Chief Minister's Secretariat had to seek clarification from the Handloom, Textile and Sericulture Department. The Secretary to the Government of Assam, Handloom and Textile subsequently inquired and submitted another report by letter dated so, which pointed out a series of irregularities in the recruitment process, leading to registration of a regular case inquiry by the Chief Minister's Special Vigilance Cell. That based on the report of the Secretary, Handloom, Textile, Sericulture Department, following incorrect, misleading facts were found in your report, that you mentioned in your inquiry report that selection committee in his meeting held on so had requested chairman of the committee for putting up question paper for interview written test, and the then director, for her convenience, constituted a subcommittee at her discretion to keep process confidential and to prevent any leakage of the question paper. However, Secretary Handloom and Textile is in his inquiry report dated so confirmed the fact that minutes of the selection committee meeting held on so was specifically silent regarding formalities of subcommittee for the purpose of selection of master weavers. Also, there was no record of government approval regarding constitution of subcommittee other than selection committee constituted by... Well, if this is how a roving inquiry is to be made, then we can find fault with everything, my lord. My duty was to make an inquiry. I may not have done the inquiry to the best of my ability, but that cannot attract a disciplinary proceeding. Misconduct connotes something else. And most importantly, my lord, the premise is a synonymous, anonymous complaint. There is a judgment of our High Court, my lord, Yes.
The notice was complaint against the director.
Yes, director and other.
Director. But you were tasked with the
Making inquiry whether there were irregularities. I found, whatever I found, I gave my report. Now please come to para 2, Miller. At page 237. The petitioner has put to challenge the action of the department in initiating a disciplinary proceeding against her by issuing a show cause notice dated 3/4/21. The primary ground of challenge is that such initiation is based on an anonymous complaint, which is not permissible under the law. Petitioner has also alleged that the aforesaid anonymous complaint had been lodged only to harass the petitioner, but also to not only to harass the petitioner, but also to cause impediment in her career progress. Now please come to para 22. At page 240. At this juncture, the learned senior counsel has also drawn the attention of this court to the affidavit in opposition of the respondent filed in this case, wherein at paragraph 10 and 15 it has been admitted that show cause notice is indeed based on an anonymous complaint dated 21/21, and this aspect is also not disputed by Sri Gogoi, the learned standing counsel. The applicability of the office memorandum dated 8/10/18 of the Government of India, Ministry of Personnel in the state of Assam, not being disputed and rather categorically admitted by the written instruction dated 9/9/21, there remains no other option than to come to the conclusion that initiation of disciplinary proceeding by show cause notice is bad in law in view of the clear guidelines laid down in the office memorandum dated 8/10/18. The mere fact that the petitioner has submitted a reply to the show cause notice would not be a hurdle for this court to interfere in the proceeding in view of the clear mandate laid down by the OM of the Government of India. Further, CVC circular number so-and-so fortifies the aforesaid position. It appears that office memorandum has been issued to prevent harassment which may be faced by competent and eligible officers in their service career, and with this purpose the same has been issued, and that purpose and object should not be allowed to be frustrated in the case of this present nature, where allegations per se also appears to be mere error of judgment, as has been held by the Commissioner Taxation. Here also, my lord, it could be an error of judgment also. That J. Ahmed's case is there, my lord, that Mohalloy, the Deputy Commissioner's case, where he could not control the mob, my lord. Government of Assam instituted during that language disturbance. A disciplinary proceeding was initiated. Then our High Court said, no, it cannot amount to, misconduct. If the matter was carried to Supreme Court, as a reported case, Supreme Court says, sorry. Misconduct is one thing, and not being able to perform one's duty diligently, that cannot be construed as a, well, in my perception, those were the, fallout of the inquiry. Somebody else could again view it from different angle and can always come to different conclusion. Merely because another view is possible, my view may not be wrong also, my lord. So on that premise to say that I have committed misconduct it will be too far-fetched, my lord. And secondly, my lord, this was supposed to be looked into by the senior most secretary. Now, if your lordship would kindly come to hello, if your lordship would kindly come to page 11, para 9 of the writ petition. These are our pleaded case, my lord. Para 9, page 11.
Yes.
That it is humbly stated that the petitioner was shocked and surprised to receive the said show cause notice on 3 counts. Firstly, his inquiry report was submitted to the secretary, senior most secretary of the department, who was required to give his views on the same, meaning thereby petitioner's report was not final or conclusive. If any shortcoming was noticed, it ought to have been pointed out by remitting the matter back to the petitioner for rectification. In any such eventuality, the necessity of submitting another report by the secretary would not have arisen. Secondly, if the departmental secretary, senior most secretary had endorsed the finding recorded in the inquiry report of the petitioner, then why only the report of the petitioner is sought to be faulted with? Thirdly, a disciplinary authority has the power to disagree with the findings of the inquiry. However, in such a situation, the inquiry officer's finding perhaps would not come with the purview of the misconduct. Otherwise, in all cases where the inquiry officer's report is not agreed upon by the authority concerned, would entail a departmental proceeding for misconduct against such officer. If such a situation is allowed to prevail, then very concept of free and fair inquiry would lose its significance, as the inquiry reports would be given to appease the departmental authority. So these are the Milord articulations which I would like to make. And my lord, my report I submitted to the secretary. He is to endorse it, then it will go. Then why have you not chosen the secretary also? That, my lord, our High Court case which went to Supreme Court, that BRPL case, where Supreme Court says if a particular 2007 7 SCC 206. What had happened, my lord? This gentleman called Girish Chandra Sharma, my lord, he along with some other person were given the task of identifying a plot of land in Jorabad for setting up a retail outlet. Now, in the process of identification of that retail outlet, some, my lord, infirmities were noticed. Then there was a disciplinary proceeding initiated against Girish Sharma to the exclusion of the others. Then our High Court says it is not only Girish Sharma who is guilty, the others are committee also are also guilty. Since you have not taken any action against the others, you cannot take action against him. Then matter was carried by us to Lord Supreme Court. Then what Supreme Court says, Gossips will find that paragraph number 17. All the three committees, that is the tender committee, along with the respondent, other 4 members were there. And similarly, in techno-commercial committee, along with the respondent as member, there were other 4 members. And likewise, in the price negotiation committee, Sri P.C. Goswami, General Manager Marketing, was chairman, P.K. Borua, Deputy General Manager, D.B. Das, so-and-so, P.K. Gogoi, etc., were members. After going through the report and finding recorded by the division bench of the High Court, we are of the opinion that in fact the division bench correctly assessed the situation. The respondent alone was made scapegoat, whereas decision by all the 3 committee was unanimous, decision by all these members participating in the negotiation, and the price was finalized accordingly. It is not the respondent alone who can be held responsible when the decision was taken by the committee. If decision of the committee stinks, it cannot be said that respondent alone stinks. It will be arbitrary. If all the fish sting, to pick one and say only it stings is unfair in the matter of unanimous decision of the committee. In all the 3 charges, respondent was found to be guilty for not assessing the reasonable price in his report submitted by him, where the price indicated by the owner of the land was fair. So, the appointment of Sri I. Sharma as a valuer of land valuation was not also the decision of the respondent alone. And the exploration of the soil and rock strata given to the company limited was also not the decision of the respondent alone. Therefore, all the 3 charges which have been framed against the respondent as if he alone is responsible for the deal is not correct approach. It is also not necessary that landowner who has given the offer at one point of time at rupees 30 lakhs to stick to that. Instead, she has intimated the appellant company by letter quoting the price of rupees 61 lakh, and that was subsequently negotiated and brought out to 50. So, my lord, these are the facts. Yes, Supreme Court says if a decision is taken collectively, you just cannot pick up one of them and proceed against him departmentally. Here also, my lord, it was regarding the price fixation, where here also, my lord, there may have been some shortcomings. That does not mean, my lord, it amounts to misconduct. It's something like a lower forum deciding an issue then in appellate forum, my lord, the order is overturned. Does it mean the lower?
What is the punishment? What
My
is the
lord.
penalty imposed?
Yes. Initially, my lord, there was one increment. Then I filed an appeal, and that was converted to a censure. But because of the censure, my lord, my juniors have superseded me to IS. That in the affidavit they have clearly said. If your lordship would kindly take the affidavit in opposition of the respondent, my lord, paragraph 17, I'm only pointing out regarding that supersession part. Page 151, affidavit of the department. That with as a lordship got it.
Yes.
That with regard to the statement made in paragraph 19 of the writ petition, the deponent denies the same, and this connection the deponent further begs to state that the name of the petitioner has not been left out from the civil list published in November 24. As per record, his name has appeared at serial number 78. It is pertinent to mention herein that zone of consideration for nomination to IS from ACS is prepared on the basis of seniority as on 1st of January of that particular select list. For the select list 22-23, some officers of direct recruit 93 batch have been included in the zone of consideration as per their seniority. However, the name of petitioner has not been included in that zone for consideration. So they admit, my lord. Now kindly come to my reply, my lord. My reply starts at page number 158. If lordship will kindly come to 162. That is, statements made in paragraph 17 of the affidavit in opposition being wholly misconceived and baseless, the petitioner categorically denies and disputes the correctness of the same. In this regard, it is humbly stated that the petitioner belongs to direct recruit 93 batch of ACS officers, and during the pendency of the departmental proceeding against the petitioner, all his batchmates have been given promotion. Even officers junior to the petitioner have also been promoted. At present, the batchmates of the petitioners are working in the grade of secretary, ACS cadre, to the government of Assam, whereas petitioner is presently serving as additional secretary to the government of Assam. Further, had the petitioner been promoted along with his batchmates of direct recruit 93 direct recruit batch, he would have been placed at serial number 30 instead of serial number 70 of the ACS civil list published in the month of March 2025. Therefore, it is apparent that due to initiation of the departmental proceeding on flimsy pretext, the petitioner has been superseded not only by his batchmate but also by officers junior to him, thereby causing great and serious prejudice. The admitted position is, my lord, not only my batchmates, even my juniors have superseded me. Therefore, my humble submission is, my lord, lordships will not only interfere with the impugned punishment, lordships will also direct the authority to hold the review DPC so that my case is considered when my immediate junior was promoted to the IS. Well, they could have adopted seal cover, which they have not done. I can appreciate because DP was pending, they could have, and now once the matter is over, they can open the seal cover. That was also not adopted. That's my humble submission.
In regard to the lordship, page number 151, that portion part, for select list 22 and 23, some officers of direct recruitment entity base have been included in the zone of consideration for their seniority. However, the name of the petitioner has not been included in that zone of consideration. On that part, I have one instruction. Here, what is the whole thing is that here, 2024, arising with 1/1/2024, 2024 is under process in the personnel department against the select year of 2024. There are 3 vacancies to be filled up from ACS officers for promotion to IS cadre, in which there will be 9 officers in the zone of consideration, and Sri Hari Prasad Bora, writ petitioner, is not among the officers as per the consolidated seniority list as on 1/1/2024. as such and inquired for, there is no move to nominate the writ petitioner to the highest cadre at present. Against the select year 2025, vacancies arising between 1 and 2025 to 31st 2025, it is expected that 15 vacancies due to retirement shall arise for promotion of ACS non-ACS officers to IAS, which is subject to concurrence of DOPT Government of India, as done in previous years, and as per administrative practice, the concurrence of vacancies for state civil service and non-state civil service separately for DOPT Government of India for the select year 2025 will be obtained only in early part of the year, 2026. The question whether the writ petitioner would be in the zone of consideration among the list of eligible officers as on 1/1/2025.
You tell us at the time when you want to have it considered. And you think that the seniority is
No, it is not. It is totally on eligibility criteria.
What is the eligibility criteria?
What it is that as on 1/1/25 vacancies meant for state civil service officers would be examined at the time of preparation of the list of officers under zone that will be done lordship under zone of consideration for the selector 2025, subject to fulfillment of eligibility criteria and administrative instruction by the DOPT Government of India.
The eligibility criteria.
Then it was on that I have to get the special instruction because this is the case of challenge of DP lordship.
Write your affidavit. Case projected in the writ petition, read with the rejoinder, everything is clear that his grievance is that he's not been considered for nomination because of this DP.
Not because this ongoing that DP lordship. Because
where have you stated in your affidavit that it is not because of that, but some other reason?
There is no such specific stated. I think we have clearly said that it is basically made on the eligibility criteria that he has to fulfill it.
What is the eligibility?
That lordship, that eligibility criteria is the Government of India lordship. So I can lordship one, I can produce it lordship.
I'm sure you can produce it.
That's
but you should have
100%.
it. Matter is for admission hearing, you have filed your pleading.
The challenge of particularly in regard to that deferment for proceeding that was being undertaken against it, and the statement in the inquiry report is very much clear. Lordship may kindly see the inquiry report, lordship. The part of the para of the inquiry report and page number 148.
You have to just clarify and tell the court as to whether the petitioner not being considered.
No, not because there is nothing estimating out like that, lordship. It is not because of that DP. It is basically.
How do you know?
If lordship want to provide me some written instruction on that, I can provide it.
We are only asking you, how do you know? Because your affidavit doesn't disclose that. On what basis are you saying that it is not on this criteria?
Because for the language has been used in the instruction law.
You get your instruction.
In fact,
What is the criteria? No, this instruction is meant for you. You argue on this.
Finally brought this notice to the Honorable High Court.
You have brought it to the notice. We have accepted it, but we want to know that what is the basis of the
Lordship, on that one, let me bring specific instruction clearing it.
Please get it by Monday.
Lordship.
Monday.
It has faced a month's person.
Huh?
It has not a big stuff.
Monday you'll get it.
There was the guideline also. I need some time to bring the guideline of the DOP.
We don't know what guideline or instruction you want. You tell us whether you have an answer to this.
Let the matter be fixed on Monday, Lordship. I will give it a try.
My lord, it is for this DP only I was not given. Why my learned friend is making the
I don't think that it is because of the DP that you
you think 2 more days fixed on 18. Let us get
yes, 18.
That's all.
For further hearing, madam.
Verify. Round case for by
Possible.
May please your lordship. I was appointed under NHM and working as a ANM under Boroma BPSC. During my service period, I was absent 2 days due to excessive bleeding from uterus, and thereafter the respondent authority issued show cause notice, and thereafter passed impugned order page number 26, whereby transferred me from Boroma BHC to BPHC to Zabrangpur Subcenter under Niskaurba BPHC. But the respondent authority has filed thereafter before this honorable court that he has no authority to pass such order by page number 72, your affidavit. Page number 72, running page number. Page number 72. Para number 3. It is pertinent to mention herein that as petitioner is an employee of NHM administered by the government of Assam only, the NHM has not been handed over, transferred to BTC administration as on date. Managing director, that is mission director, health mission of Assam is the competent authority. Hence, BTC has no role in this regard. Subsequently, by this affidavit, the respondent authority has withdrawn his authority power of transfer. The joint director of Boroma BPSC has issued impugned order. Subsequently, by this affidavit, he declared that he has no authority to pass such order. Even page number 67, running page number.
Has he withdrawn that order?
Yes.
Has he?
No. He has not withdrawn, but he said that he has no power to pass such order. As the appointing authority NHM. Order page number 67. The higher authority has already cancelled the all attachment order passed by the joint director.
Yes, who's called PTC?
We have a,
Huh?
I think
RK? Mukar, yes.
file this affidavit from the page 72.
Yes. What do you say? You have made an averment that you have no role.
But in this way, it is. This way it is reposed, my lord. Actually, to comply with the
All are cleared. All facts are cleared by this affidavit.
page number.
Where is Mr. Mukar? Where is he likely to get? Next. We inform him, pick up the matter next.
Next.
Let the standing council be present.
That may be fixed.
Yes, next week. What 19? 19.
Lordship, this is a petition against a transfer order. I joined service the National Housing Bank in August 22. I was transferred to Guwahati in June 22. I joined. August 23, I transferred to Guwahati. And then I stayed here for 1 year, 8 months. And by virtue of the impugn order 13/3/25, I'm transferred to Thiruvananthapuram. I made a representation on 20th March, which is being rejected, not accepted. Doctor, may I just show you quickly the transfer policy?
Yes.
Page 18.
Which organization are you working?
National Housing Board.
Bank.
Bank, National Housing Bank. It's a Government of India. Doctor, page 18. This is their own transfer and job rotation policy, 2022. Page 20, number 3, job rotation process.
Yes.
3.1, tenure. It shall be the endeavor of the bank that an officer is allowed to work for a minimum number of years in the same department to facilitate learning and skill development. The minimum tenure can be as under. I fall under 1, which is scale 1, 2, 3, and 2. And minimum tenure is 4 years. So there shall be an endeavor. Of course, there is a caveat. In case of administrative exigencies, the competent authority can effect transfer of an officer in other departments and offices even before completion of the minimum tenure. They always have the power. Lordship, now 4. An officer shall be considered for transfer to other stations place after 5 years. So the tenure seems to be you stay in a place for 4 years to 5 years. And this actually has come pursuant to a Supreme Court direction, so to speak, to all concerned, that there must be some amount of minimum tenure, so that's how you extract best for employees. So the tenure according to this regulation is 4 years for for scale 2, which is concerning us, and here it says generally after 5 years. And what it says is after 5 years of continuous service at the same station, the bank shall prepare scale-wise list of officers who shall fall into zone of transfer to other station place in order of maximum tenure spent at the same location at one stretch. So they're supposed to have this scale-wise list. The transfer shall be based on first in, first out basis. 4.3. All the officers falling under the zone of transfer as on January 1st each year shall be given prior notice calling for option choices of 3 locations. The transfer of the officers along with request transfer cases shall be recommended by a committee with the following composition. So there is an option. You ask every year, 1st of January, they're asking for requests, and then you give them 3 options, and then those 3 options are considered. 4.4, Your Lordship. While considering any request related to transfer retention, the priority shall be given in the following order: person with benchmark disability, etc., etc. And I am on the last one, page 22. Health grounds of dependent family members, including persons not concerned, health grounds of family members. So I made a representation saying that I joined service, I was in Delhi for 1 year, which is less than the regular tenure. I came to Guwahati. I'm just here for just about 1 year, 8 months. And I brought my mother in. And my mother is not well. So kindly consider not transferring me out of Delhi. They refused that. So after the representation has been refused, Lordship, we've come to your Lordship's, knocking Lordship's door. And my prayer is that we've in fact submitted medical records of my mother. She's severely diabetic. There's something called diabetic nephropathy. Nephropathy. So she's suffering from that, and the advice is that she needs to take care and treatment from a higher center. And they live in Asansol. So which is why Guwahati is easy. So my prayer is I understand that they have the power. Transfer is intrinsic in service, but the policy requires a minimum period of 4 years to 5 years, subject to exigencies and public interest. And they are relying on the fact that there is a exigency situation. But exigency can't be that nobody else can go to. The affidavit say it's rationalization of manpower, and that his post here nobody is appointed, so they don't need that post. My prayer is there are other places for him to reach Asansol. He has to go to Calcutta, Bangalore, and then Trivandrum. So my prayer is, as an employer, he's expecting a little bit of empathy and a little bit of compassion. Consider there's Ranchi, there's Calcutta, there's Ranchi, Calcutta, Patna. They can consider placing him somewhere there. They don't need him here.
Where is the impute order?
Impute order, transfer order is at page 10. It's a combined transfer order for 53 people. Page 10.
Your name is?
At page 12. I'm the only one from Guwahati. The affidavit says 5 others, but my instructions are, we also said that in our affidavit, rejoinder, that I'm the only one. Serial number 43, Your Lordship. Mr. Shubhan Singh, Guwahati. And the prayer is, if there is a period of 4 years, he must not be every time asked to leave. And considering the fact that now his mother is not well and he's asking for a certain amount of accommodation, ideally we should not have been required to come here. But and my representation has been refused at page 101. Just one line. They've annexed it to their reply. We regret to inform that the competent authority shall not accede to your request. My prayer is that on a compassionate and humanitarian grounds, instead of sending him so far away when there is a medical need for the next couple of years, and he's not even, as per the transfer policy, he's not yet completed 4 years. So typically he must not be shifted out. Not if there's a Supreme Court judgment on the basis of which these transfer policies have come into being, which emphasize the need for a minimum tenure. I'm not even arguing that they can't. They can. If there is an exigency and if there is public interest, paragraph 30, Your Lordship. This is the genesis of these rotation policy. Paragraph 30, page 14, internal. Lordship has it, last line. We notice at present, the civil servants are not having stability of tenure, particularly in the state governments where transfers and postings are made frequently at the whim and fancy of executive heads of political and other consideration and not in public interest. The necessity of minimum tenure has been endorsed and implemented by the union government. In fact, we notice almost 13 states have accepted the necessity of minimum tenure of civil servants. Fixed minimum tenure would not only enable the civil servants to achieve their professional targets, but also help them to function as effective instruments of public policy. Repeated shuffling transfers of officers is deleterious to good governance. Minimum assured service tenure ensures efficient service delivery and also increased efficiency. They can also prioritize various social and economic measures intended to implement for the poor and the marginalized sections of the society. We therefore direct the union, state governments, and union territory to issue the appropriate directions to secure providing for minimum tenure of service to various civil servants within a period of 3 months. Pursuant to this, perhaps the rotation policy has come into being. So my prayer is, as an employer, I can understand there is an exigency, but it is not that nobody from the entire organization can go to. The exigency can't be that there is nobody in the organization who can go to Kerala. And they say rationalization of manpower and you don't need his extra manpower in Guwahati, then they can let them consider at least other options. That is my humble plea.
Yes. Yes.
Lordship, I'm not sure whether they are trying to enforce the transfer policy or they are making this petition on compassionate ground or has the semblance of a mercy petition. If it is a policy, there is a specific. Lordship will kindly come to the policy 4.5. Yes. Learned friend has shown 4.1. It has come to paragraph clause number 4, transfer. So 4.1 says, which they are relying, an officer shall be considered for transfer to other station based after 5 years of continuous service at the same station. The bank shall prepare scale-wise list of officers who shall fall into zone of transfer to other station. This in order to order a maximum 10 years spent at the same location at one stage. The transfer shall be effected based on first in, first out. So that is what they are relying. Now Lordship will kindly come to 4.5. Next page. 4.5 says, notwithstanding the content of the policy, the management shall have the right to transfer the officers on account of administrative exigency with due approval of competent authority. And Lordship will also come to 4.8.1. Administrative transfer. NHB, National Housing Board, orders suo motu in the exigency of service and administration and in public interest. Further, the officers found guilty of major misconduct, disciplinary, which is not her case. This is transfers may be broadly classified into administrative. So the transfer which we have now affected is falling under 4.8.1. Why? Lordship will have to take the affidavit where the factual matrix is very clearly stated. If Lordship is pleased to come to paragraph 5 of my affidavit. So in paragraph 5, we have said about the National Housing Bank Service Regulations 1997, which we have annexed. Now, paragraph 6, we talk about transfer and job rotation policy. Now, Lordship will kindly come to paragraph 7. May I read it? The deponent humbly begs to state that as per clause 2.4 of the transfer policy, all employees are liable to be transferred anywhere in India, including limited duration transfer at any point of time, and transfer to a desired location cannot be a claim as a matter of right. As per clause 4.1 of the transfer policy, an officer shall be considered for transfer to other stations based after 5 years of continuous service at the same station. But in the same policy, clause 4.5 states that notwithstanding the content of the policy, the management shall have the right to transfer the officers on account of administrative exigence. The number of years of service at one station is not the only criteria for transfer of officers. As per clause 4.8.1 of the transfer policy, transfer can also be effected based on administrative and business requirement. This is precisely our case. In terms of the transfer policy, NHB has undertaken annual transfer exercise by office order dated 13/3/2025, which has affected transfer of various officers across the organization for effective administration and keeping in view of the requirement of the organization. Why the transfer order dated, that is what is put to challenge in respect of the petitioner, 13/3/2025. Many officers, including petitioner, who have not completed continuous service of 5 years at one station have been transferred, owing to the administrative and business exigencies requirement of the organization. Next paragraph. While order dated 13/3/2025, NHB has transferred 53 officers across the organization, owing to administrative and business exigencies requirement of the organization and for rationalization of manpower. Out of 53 officers transferred, about 29 officers, including the petitioner, did not complete continuous service of 5 years at one station. Further, 5 officers, including the petitioner, were working in Guwahati office, and 2 officers were working in Tiruvandana office. The petitioner, along with another officer working in the regional office, Lucknow, have been transferred to the regional office, Tiruvandanapuram, for the purpose of rationalization of manpower. No other officers have been posted in regional office, Guwahati, in place of the petitioner. So in Guwahati, there were excess officers shortage. Therefore, in Tiruvandanapuram, there was shortage. So one from Lucknow and one from Guwahati are directed to be posted there. And as a In this exercise, total 53 officers were transferred and 29 officers did not have that requisite period of completion of 5 years period in one station. So it is not that he is singled out. Now, one important aspect, Lordship, will kindly come to here, paragraph 10. This is a very critical issue. The deponent denies the averment made by the petitioner, humbly begs to state that upon request of the petitioner for transfer to Kolkata office or any other places near Kolkata, he was transferred to Guwahati in the month of August 2023. The petitioner has suppressed the fact at his request of transfer, he was transferred to regional office Guwahati from the head office Delhi. So he is working in Guwahati office for 1.5 years. It was at his own request. Otherwise, he would have been in Delhi, where he would have completed 5 years. So this very vital fact he has suppressed. So now, basically the repetition of the fact and the law governing them. Now, number 2, whether these guidelines are enforceable, whether this has the effect of a statutory right. In my humble submission, so many cases Lordship has dealt also, and by this honorable court, as well as by the Supreme Court. Unless there is a malafide intention, or there is violation of any fundamental right, or in case there is a case of frequent transfer, the person in impugned order or transfer order can be interfered by this honorable court. The law has been well settled in that 1993 case, which has been repeatedly followed in all subsequent cases. That case is Lordship 1993 4 SCC, page 357. Union of India versus SL Abbas. Paragraph 7. Who should be transferred where is a matter of for appropriate authority to decide. Unless the order of transfer is vitiated by malafide or is in violation of any statutory provisions, the court cannot interfere with it. While ordering the transfer, there is no doubt the authority must keep in mind the guidelines issued by the government on the subject. Similarly, a person makes a representation with request to his transfer, the appropriate authority must consider the same having regard to the exigency of administration. The guidelines say that as far as possible, husband and wife must be posted in the same place. That is in respect of that particular case. But the basic ratio laid down in this case and which has been till today, it is in effect that unless there is a malafide intention of the authorities or there is a violation of any statutory provision, normally the court would not like to interfere. In the case, there cannot be any malafide. In fact, the authority was in his favor while allowing his request of transfer to a place near Calcutta in about 1.5 years ago, while he was transferred in.
Let me just summarize it.
Yes.
There is a policy.
There is a policy.
Right, wrong, policy.
Whatever.
It's in the form of a guideline.
It's a guideline.
It doesn't give statutory.
Right? No enforceable right can emanate from that policy.
Correct. Now, but there is a policy.
There is a policy.
This policy is framed by the
authorities. Yes.
Now, whether the petitioner has been transferred in terms of the policy has been given an exception under certain exigency. This court has some level, either by way of an affidavit, that these are the reasons why we are transferring you. Now, even taking into account request that they have come to Guwahati at their own
request.
That's again endorsed by the authority.
Yes. At that point of time, there was no exigency of service.
Therefore,
now there is exigency of service because Tiruvandhanam office, our office in Tiruvandhanam, there is shortage of staff of his rank. So there were only 2 persons who was manning Tiruvandhanapura.
Were these guidelines not there when he was transferred?
No, his guidelines were always there. That guidelines, but in the guidelines itself, 4.5 and 4.8.1 very clearly.
The transfer order, yet
they have not disclosed it. We have disclosed it on our affidavit.
Is it available somewhere? Order in the form?
We have not annexed it, but I think otherwise we can always submit.
Tell me, was it a conditional order that you are now transferred to Guwahati, but as that when required you have to call?
There in 1.5 years ago, it was not contemplated that a rationalization exercise has to be conducted by the board across the country. It is a pan-India exercise where 53 number of officers are shifted from one place to another so that proper officers and proper number of officers are manning each office. It has been found after 1.5 years that Tiruvandhanam office is having shortage of staff. Therefore, one person from Lucknow, one person from Calcutta, in Guwahati. And in Guwahati, it is overstaffed.
The bank was not under an obligation to frame these policies. Why have you framed these policies?
These are general policies. These are
You
general.
don't want to follow it.
Otherwise, no.
If you are saying that no, these are cases which are an exception under this policy.
Yes, Lordship. Also, Lordship.
Some material to say that no, these are the grounds on which rationalization is a very omnibus term. Rationalize.
Absolutely. It's a now. If
the authorities are required to at least justify that no, these are areas where rationalization or reasons, at least in
rationalization, the reason is very clear. Now, in his place, we are not bringing any other person. That means Guwahati has over excess staff. That is why one person is shifted from Guwahati and in his place, nobody is coming here. It is not a two persons interchanging
you consider
or swapping.
You consider his request on
Lordship,
these grounds.
Lordship may pass that order. I do not mind that.
We will close the matter. You consider pass order in the detailed order.
Detailed order. No.
Pass a detailed order.
I think one submission has been made from the other side that a representation has been submitted and it was already rejected.
We will file another representation.
Transfer is an incident of service. There is no quarrel on that.
Lordship, one more thing. 2.4. Let us come to 2.4. National Housing Board shall strive to ensure efficient functioning of the organization and optimize job satisfaction amongst employees. All employees are liable to be transferred anywhere in India, including limited duration transfer at any point of time, and transfer to a desired location cannot be claimed as a matter of right. In the policy, it says that. We have to also read only what is saying is 4.1 that minimum 5 years. That is one. But let us go to 4.5 now. Notwithstanding the content of the policy, so whatever is there in the policy, the management shall have the right to transfer the officers on account of administrative exigencies with due approval of competent authorities. So, when there is a violation or there is a aberrations from the policy, then the competent authority, that is the highest authority, it is not their case that there is no approval of the competent authority. In our case, there is approval from the competent authority.
Or that you produce the reports.
Yes, I'll show you. No difficulty. And next, 4.8. Transfer may broadly be classified as administrative transfer, NHB orders suo motu in the exigency of service and administration and in public interest. So we can do administrative transfer. So all these are allowed and permissible under the same guidelines, same policy.
We are not questioning your policy.
Lordship.
But the same policy also has certain other aspects where it talks about rotation, transfer, etc. This is the minimum. Now, you produce some record, let us examine and see whether there are genuine reasons. I'm sure there are genuine reasons for
genuine. Not basically to this particular petitioner. It is a pan-India genuine reason.
Right.
Therefore, let us see, Lordship, the impugn order. What is it stated in the impugn order? Yes, impugn order, Lordship will kindly see page 10. It is the first part is not properly eligible, but in the same order, his name is at serial number 43. So, a massive exercise was undertaken by the Housing Board, where so many officers were shifted from one place to another for the purpose of exigency of service and for the purpose of rationalization.
Therefore,
Lordship wants record, I will produce it.
Therefore, we thought it is best close the petition. Ask him, we'll permit them to file a representation within a week or so. Pass orders on detailed orders and serve copy.
No reason. Absolutely no reason. But the result will be same.
Yes.
I'm obliged. Lordship, my thing is there is no
that
dispute.
submission will not record.
No, because that exercise has already been done.
Maybe, but we are asking the bank to do it again.
Lordship, my humble submission is the policy is to aid better working conditions. The policy is not from a place of arrogance. It's from a place of empathy and
You
looking.
are employed in an organization. The organization desires to transfer you on the ground that
Yes,
your
Your Lordship.
service
The only option
required, whether there.
yes.
Uh,
And I cannot.
Not that you cannot, but that the
It
question,
becomes difficult to continue.
it is presumed that the organization has taken everything into consideration.
Yes.
Unless you allege malafide, you have not.
No, we've not alleged. At this point of time, there is nothing to allege malafide, and we've not alleged. My submission is there is a policy, and I understand there are exceptions to policies carved out in the policy in the form of exigencies and public interest, which they are relying on to seek a transfer. The transfer has been for 59. Out of those 59,
Right.
if one, Lordship, I am relying on 4.4 while considering any
We are
request.
disposing it off with a direction to the who is the authority to consider.
It's there. It's page 25. It is.
Where is your representation? Have you filed a representation?
Yes, Your Lordship. Page 15. But the competent authority is page 25, Lordship. It's for scale. It's DGM HRMD. It's in the policy itself. For issuing transfer order.
The earlier representation was addressed to General Manager, Human Resource Department, National Housing Board. Page 15, the address is there.
The same authority, General Manager? General Manager
I have
is
found,
not a party.
or in the read petition, they have made the Managing Director.
Yeah.
So who is the authority to that Managing Director?
So,
Lordship, under the policy, it's DGM HRM for my category.
so let
Page
us see who
25.
has issued the impugn order.
Yes. Page 10.
General Manager.
General Manager.
General Manager. If you not even arrange General Manager a party.
Idea?
Managing Director is the party, not the General Manager. But I am also relying on another judgment, Lordship. 2017 to GLT page 20. The learned single judge's order, but number of Supreme Court cases are discussed. Where also the main question was whether Office Memorandum dated 6/8/2023 laying down the policy guidelines for transfer, whether it is enforceable. The finding of the Honorable Court was not enforceable.
Well, there is no quarrel on that.
Yes, there is no quarrel on that.
Because their whole case is based on the policy. That's why I'm making this submission and citing this judgment.
No,
Their case is on the policy, and particularly they have said that they want mercy. This is their case.
No, Lordship.
Compassion. They are using the word compassion.
If a state
I have
authority
noted
takes
down.
compassion or mercy, there's a problem.
And empathy. These are the
That's
words
right,
they have
that's
said.
right. Mercy
I
is
have
the
to
right
play
word.
with the words. I have to play.
No.
I have to
The
hear what.
connotation is there's arrogance. I am
There is no
seeking
arrogance,
compassion. I am
in my
seeking
humble
compassion. I am not seeking mercy. Mercy is,
They are using the word empathy and compassion.
Lordship, I am relying on 4.4. While considering any request related to transfer retention, priority shall be given in the following order, and there is health ground of dependent family. So I'm not challenging rationalization. I am not challenging need. That is their prerogative and they will decide. But it can't be that there's an entire organization. There's only one man who can go to Trivandrum. If he can establish that for a little while he needs. That's the consideration I require. Empathy, nothing
The
more.
reverse, you must keep the reverse in mind. The organization can function without.
Right.
You can attend to your relations.
Which is an unfortunate situation if the organization looks at it like that.
No.
I agree with you.
As
It's an
an
unfortunate
employee,
situation.
as an employee, you are You do have
Which is why, Lordship, I am not. What is my submission? My submission is my mother is not well. Will you please consider try one of the nearer options than Trivandrum, because she needs to probably go into dialysis and everything. So getting 3 flights is difficult. Than getting a 1 flight. That is my submission.
But Bandra likely to have better medical facilities also.
No, I think taking mother is now, I think, settled in Guwahati. That is his problem. He's brought her here, and then Lordship, this whole thing of request. The organization on 1st of January asked for request. I have an email.
You're not claiming caregiver under the Disability Act.
No, Disability Act perhaps not, but I'm a caregiver. I'm the care provider. I'm the son who has to look after. I'm saying that there is a the policy itself embodies compassion for its employees. It's unfortunate that the organization does not embody it.
All right. Heard. We are dictating the order now because it has some minute factual issues which you can point out if I go. We should get it directed by that. Review order dated 13 March 2025 hereby petitioner is transferred from present place of 680 regional office Guwahati to regional office Tirubhanan. The petitioner is presently serving as deputy manager with bracket MMSK private in the National Housing Bank. The learned counsel that the bank has a transfer a job office to a profit the year 20. Referring to the transfer job submitted that under clause 3.1 scale Roman 1 to 3 are shown to have a minimum level of holding. So it is submitted to the petitioner falls under the scale 2, and therefore tenure of the petitioner is with the posting 54. The further submission that in terms of the policy, while considering transfer and management policy, priority is to be given priority the priority to be given are also prescribed for 4.4, where health ground health ground of dependent family members to be persons with benchmark dependent. I goes to without one ground submitted to mother. He be a diabetic. And how old is your mother?
63, 65. Lordship, I'm also relying on 4.3, which gives us options.
Senior citizen. And
I was never given an option.
And therefore, the petitioner's mother presently being settled in are dislocated to the new place of posting because they are including disrupting her treatment, undergoing her treatment, which is counted for the treatment for letter was going to be submit that the officers within the zone of transfer as of January 1 each year shall be given a prior notice common calling for auction slash choice of freedom in submission of such auction or choice or call for the council. Therefore, that the while administrative accident can be a ground for transfer. However, the policy framed by the bank, there is a provision for laying down the parameters and the criteria transfer policy, which the government or and so the representative side with having no alternative court transfer. Like back from your need that brings the transfer policy. We submit that transfer being an incident of service, notwithstanding the parameters laid down, even under clause 4 of the same transfer policy. Administrative accidents, one of the grounds on which transfers can be effected. Clause 4.5 is drawn the attention to clause 4.5 that notwithstanding content of the policy, management shall have the right to transfer the officers of council and state state with due approval from the authority. That apart, under clause 4.8.1, it is provided that the National Housing Bank orders suo motu transfers in exigencies of service and administration public. Referring to the impute order, government for the respondent submit that this order clearly reveals that the petitioner not the only officer picked up transfer. There are as many as 52 officers, various scale categories, who have been transferred to different places. The petitioners named here that serial number 43. The
Out of which 29 have not completed 5 years.
It also submitted that 29 officers in the same case, including the petitioner, did not complete the term of 4
Maximum of 5 years
5 years
at one stage.
at one stage. Nonetheless, because of rationalization of officers and in administrative exigencies, transfers are carried out, and there is no malice or ill will against the petitioner, which is not. He further submits by referring to the affidavit filed by the respondent that in place of the petition, no new person has been transferred back. This supports the contention, the stand of the department that these transfers are would be the ground of rationalization of the various things.
Also noted that in 2023, he was allowed to come to Guwahati on his own.
He further submits that petitioner was
Lordship, I'm disputing that. Because we
My
also
submission may be recorded.
yes. Then my
But there is no counter.
no there is
raised.
we
is it
alleged
stated in the affidavit?
In our
Yes,
state
yes.
affidavit, we have
then I have the email. Lordship, it's a routine process. Every January send out an email. Do you want any option? To which I replied, I didn't ask. It's a response to do you want? And I say yes.
All right. It is submitted that
But
the
in any case, it doesn't.
petitioner was posted in Guwahati as he requested for a posting requested for transfer of posting to Calcutta office or any other office near court. And accordingly, he was transferred in the month of August. Mr. Vikia represents the export in Hyderabad.
Lordship, just to show, this is the email they sent us. Give the 4.3 which I done, give 3 options.
So we are dictating the
So just clarify that.
Hyderabad reported in that transfer in the service and the authority is their right to transfer. It can be interfered when it is in violation of a statutory form or when the transfer order is allowing. So he submits that the transfer policy to be read only to be accepted as a guideline, and it doesn't give any statutory right to the petitioner to come before the court and seek a prayer for matter. So that judgment he therefore he also refers to judgment of court rendered in Abdur Rahim Singh in support of the learned counsel other end rendered in ESR Subramanian. It was rendered in the context of tenure posting civil service. The FX court they historically held that in order to ensure effective rendition of effective service and achieving professional target, fixed minimum tenure is to be notified by head officers that something that the transfer policy of the bank was up for learned counsel for the market. It is available for executive order. See that its policy based on the criteria character for job creation process. Clause 4.4 also specifies that any request for transfer when made, priority is to be given in the following order based for 21 and 21. The case that on account of health ground of his mother, the dependent family member, petitioner's request for payment party of it is equally noticed that the transfer policy also indicates that notwithstanding the parameters laid out, the authority have the right to transfer officers out that existence with due approval of competent authority. There is also power of sumo transfer by the bank in exigencies of the administration public. The eBay improves the benefit of where is that reply
100
rejecting
The rejection of my representative 101.
email, rejection of the email is does not exclusively has to buy email email or request rejected by the reply. While there is no quarrel with the proposition that the transfer policy or the guideline not be right. In fact, made that this transfer policy is part of the policy framed by the bank. Then, while it is really not disputed that the bank has inherent power to transfer any of the administrative expenses. However, it is incumbent on the employer, namely the bank, to at least give the minimum reason as to why the parameters prescribed the clause 4.4, read with clause 3, so far as the retribution is concerned, where will not be applicable. It is not applicable. As a consequence thereof, you must forget. That the authorities will have to represented submitted by the children. And thereafter pass a meeting order thereon. After taking into consideration requests made by the petitioner, read with the provisions of read with the transfer policy and consider whether petitioner's request can be suitably considered if condition of if mother is stated to be ailing and requires constant medical care. So, any such order that passed shall be served on the make it clear that no personal gain existed. Let the let the bank reconsider the past and appropriate order within.
Let them file their application in 3 days' time.
No. We say this application itself.
Oh, Lord. So in 1 week's time, we'll file it.
10 days.
10 days.
10 days. The completed within a period of 10. It will close in terms of the. We'll give a date.
Let it be on 22nd, 23rd, 23rd of by 23rd, Monday.
By 23rd June.
For the
till the next day, till the date.
No, Lord, there is no stay order till now. He is on leave. No stay order has been granted till now.
On leave.
Yes, yes.
The Lordship has rightly said that his service may not be required also. For last 3 months, not attending the office.
He's applied for leave because he's looking after his mother. So if the employer is
no
in
such
it,
kind of order because
there's nothing like your
because on the
said.
earlier occasion, Lordship may seek a judicial order. That then on the next day, interim order will be considered. That was the order.
No, that's all right.
Therefore, no interim order may be passed.
We have
Yes, close. We are not going to take any coercive action till 20th.
That say no coercive action till 23rd.
Nothing is to be done now because till now we have not because he is on leave.
All right, but we let it. What's the difference?
No, that is, difference is there.
What
difference is there because during the course of the litigation, no interim order has been passed, and in the final order also, Lordship is not setting aside our order, and there is no scope of having any action against him.
So then we'll have to record your submission. Then we'll have to record your submission to say that to undertake that till when there
from this till today, is there any coercive action taken against him? No. Number one. Number two, her submission is that he is on leave. So if a person is on leave, how can coercive action be taken against him? He is genuinely getting the leave. Deeply obliged.
It's no coercive action is taken.
No, he can take another 1 year's leave also if it is entitled.
Till 23rd, no coercive.
So that order will give a different meaning, Lordship.
10 days.
Because
you dispose it off and
no,
transfer him out.
Lordship, then why 23rd? Let it be in 1 week's time.
That we have it on 1 week.
We are not taking because
even I'm.
And then Lordship may record
the
my
end of the
submission that till the disposal, no coercive action will be taken against him. That observation will be taken.
The same thing. Why do you want your submission to be recorded?
No, it is better than the direction from this honorable.
Lordship may record. We are fine with it.
All right.
I do not want to.
We appreciate the submission of
Yes.
the senior counsel for the response that no coercive action will be taken.
Lord.
Till disposal of
Yes.
the disposal of the representation as directed till the next date.
Then the date will be, Lordship. And in that case, 19th. 19th.
19th.
1 week, 19th is a Friday. So by Friday, 5 o'clock, he will get the order. Whatever order, this way, that way.
23rd.
Oblige, Your Lordship.
Deeply obliged.
Huh?
Lordship, I'm thus preparing on behalf of SKPD for respondent number 1.
Where were you all this time? SK Medi appearing for.
Highly obliged.
Oblige.
May I please, Your Honor?
Yes.
My Lord, in this case, the query made by your lordship, I got a point subject to observation by your lordship, my lord. My lord, my promotion has been rejected on 2 grounds. Firstly, that there is no vacancy. Regarding that vacancy position, I have filed affidavit that at the relevant time, at least 7 numbers of vacancies were there. Secondly, my position was shown at serial number 45. Regarding that 45 position, at 45, I beg to say that the provisional graduation list was prepared wrongly because
it was not challenged.
It was challenged in this case.
In this case,
Earlier-
not that time.
Yes.
It should have been challenged at that time.
My lord, that provisional graduation list was published on.
We gave an indication on the last day
Yes,
that
my lord. I'm
you
very
think
sorry.
over whether you would like to withdraw or will dismiss it.
No.
This
Very
simple
sorry, my
case is your serial
I was
number.
on the impression that I had not
No,
challenged it.
Your number is at 40. As on date,
45.
this is the position 45.
45.
Now, unless you challenge it, even today, if you want to challenge it, then you'll have to array all these people responded because you don't know you want your name to be at which place? Serial number 1.
Yes, top of the list, man.
So all the 44 persons will have to be arrayed as the party. You are going above them. If the seniority list is to be recast,
yes,
today you are below 45, 44 persons.
In this petition, I have challenged it.
I know you have challenged it, but you have not arrayed these 44 persons as party respondent.
Because at this moment, I am already retired. They will not be affected if I get something.
Says they will not be affected.
Only financial benefit I will get.
No, financial may be, but their position in the seniority list, they will have some say. They are affected party. Today you are at number 1. And because somebody files a case, you go to number 2 or number 3, will you not be affected? You may be affected, you may not be affected. It is for you to,
My lord, in that case, may I submit one thing, my lord? Actually, the petitioner was appointed by the director. If anybody is appointed by the director, and as per provision of law, he is the person of directorate level. as a director level, he was appointed in the year 1997, but the provisional list was prepared from 1999. So naturally, he was above the list.
Yeah. Array, what to array will examine only provided you make these persons a part. You have to make them a part. Date is a date to even challenge that and restructure the
So in that case, my lord, have to be allowed to read those persons.
right enough. Right. For time.
Healthy. And pretty private rest.
Right.
Must.
I adjourn. A joint request matter stands adjourned to be listed again after the meeting.
Lordship, on the last occasion, the matter was argued, Lordship.
Huh?
On the last occasion, the matter was argued, Lordship.
Yes.
So, Lordship will fix it.
Fix a date.
Yes.
19th.
Lord. Much Lordship, single player.
So, this matter, I have examined the judgments. My lord, I will make my submission. But my lord, my friend, Mr. Nayak, was regularization. Finance has a very big role here. But today he is not here. He also has to make some argument in it matter. Can it be taken up some other demand? Today I'm just keeping my card to his manner because we have to make it together. That's the problem. He is down with fever.
There is a matter which we had heard, but I think it is
yes, my lord.
for further hearing. We have fixed it in July.
Yes.
So we'll take it on the same day. We are not tagging it. We are keeping it on the same day. We had fixed it on 15th. We are fixing this on 15th.
Senior counsel P.K. Goswami is ready to take it.
15 July.
Oblige.
Till Tuesday matter. I'll take my argument on Tuesday. Thank you.
And on Thursday, my lord, senior advocate has some difficulty. On 19th, my lord.
19th.
Well, I have prepared a written submission that day,
Whichever. Do it that day, you can do it today. Up to you. Better to give it that day. It's not 15th, and it's not for 8th.
283.
On hearing, I think one is very
Yes.
It's complete.
Keep it on 19th then. 19th. 19th June. For audit.
Let
That is it. No, here the matter is that petitioner was with regard to insult of his wife. One complaint was prepared before the authority concerned, and in that in that complaint one inquiry was conducted. Accordingly, as per the authority, that complaint was false and frivolous. Accordingly, departmental proceeding was drawn against the petitioner, and pursuant to that departmental proceeding, penalty has been imposed upon the petitioner as a reduction of time scale. That is the case.
We last order we said whether any misconduct is defined.
I do not find anything in the act and the rules.
We are having it on 19th.
Nothing specific in the act and the rules.
I think it's there, but is there any way of
Not specifically under the CISF organization, but there is something in the CCS conduct rules like frivolous allegations.
maybe Assam Rifles or Army?
Here I have.
So the complaint against somebody it was not true.
Because yes,
can it be treated?
Here is a yes. Here is a complaint which is untrue.
There is no finding that it is untrue. The allegations are not.
Allegations are not yes. The allegations made.
Allegations are not put in. It's not sufficient. Settle any responsibility of the delinquent. But can the complaint is sent like?
That
it's not a case where he filed a complaint that did not come for evidence. Like
yes.
Huh?
Lordship.
He did not come
no,
for evidence.
what
No,
he has his lordship. Here is a complaint already. He has recorded some conversation which he wanted to place before the authorities. Lordship, that is conducive enough.
So in the complaint we saw, it is culminate inquiry.
Yes.
What was the finding in report?
Technical notice page 22 of my.
22.
Yes.
The prayer.
Of my
Your remit.
basically, lordship, if I may say so, let me understanding a language.
So why is he now?
If I may just read paragraph 3. What was the material help? The charged officer it is right. Sure. Very sorry. As officer was there. Indian Gadi are family goes लोगों की being asked by the he has lost the complaint. His complainant's wife was also obscene word was uttered against his wife. The complaint of the charged official that is going to go, then ask applicant obscene word really indicates of having evil thought and intention. Where the word Mikey was included. And therefore, he had lost the complaint. Obscene words were uttered.
What is the punishment if
That is one stage.
Let's say reduction pay by one stage from rupees 60,400 to rupees 58,600 in the time scale of pay as per matrix level 7 for a period of 2 years. During the period of reduction, he will earn increments of pay, and at an expiry, the reduction will not have the effect to postpone his future increments of pay. This is the punishment.
no? I want to know that he first lodged the complaint against CEO. What happened there? Was it inquired?
There was a preliminary inquiry in which
Where is the report of that?
preliminary inquiry report is not just here, Lordship. In which, Lordship, as it appears from this paragraph 3, the statements of one Deepika Borua and civil drivers were taken into account. They were there. And it particularly revolves around the word of Mikey, Lordship.
No, the witnesses say that there was no altercation between the Tulsi Gogoi and the
There was
driver.
altercation.
And the driver.
Tulsi Gogoi said somebody dropped somebody's Mikey in the
No. The petitioner had gotten an report of the disputed someone family has been dropped.
Yes.
Yes.
Where were you? You're not.
Yes.
And then Gogoi, when made inquiry, then came back and said,
Asked one Hemantabar.
Ah.
Hemantabar was dropped. His wife.
Then
Then, my lord, Tulsi Gogoi asked over telephone that মই সেইকাৰণে সুধিছো কাৰ মাইকীক থলেহি মাইকীজনী বেলেগৰে আপোনাৰ নহয় derogatory my lord. Why you will take this to happen? Cannot.
What is derogatory?
My lord, মই সেইকাৰণে সুধিছো কাৰ মাইকীক থলেহি মাইকীজনী বেলেগৰে আপোনাৰ নহয় মানে indicating his wife. My lord, he is my lord,
According to him, he does somebody and something he understands somebody else's wife, not his.
Lord.
What he wanted to convey.
My lord, this sentence he will not understood it's my lord, it's not a sound word.
So therefore, I want to find out what happened in the inquiry against the fighting.
That I'll have.
That you bring it. Because here the allegation is, the charge is that act of serious misconduct. Exhibited an act of serious misconduct.
Yeah.
That he submitted a written complaint.
Yes, Lordship will see the complaint at Annexure 2 for a moment.
Annexure?
Annexure 2
of?
Annexure 2 of the writ petition.
Page 26.
And now, Lordship, simply making a complaint is one thing. I may make a complaint against my friend. See the extent to which he has got. At page 26.
26.
Page 20. Lordship will see the last paragraph. Now, this is not the way a sane person will behave, not. They are colleagues. I do not record anybody's phone call. Merely giving a complaint is something, but here he has gone to some other level. In any case, Lordship, I will place the inquiry.
Produce the data.
Yes, yes.
Yes, yeah, produce it to the court. The report of any inquiry.
The preliminary inquiry.
Preliminary inquiry, inquiry conducted on the basis of a complaint lodged by the prisoner against his colleague.
That will be immediately on
15 July.
Well, obliged.
Yes. You wanted an upgrade, we forgot you to take from the court master.
That's the illogical. But here, the writ petition, initial writ petition, Sanjeev Kumar Talwar Mallet, during the pendency of the writ petition, he has expired. That is, he expired on 26th of November 2021, and because of the road accident. Now, the wife has come. She has been substituted as a writ petitioner, but as directed by the Honorable Court, I have to file a fresh writ petition for pensionary benefits and all. And accordingly, I have filed the writ petition claiming for pensionary benefit and other service benefits which he is entitled to. He rendered, he was initially appointed in 2007, my lord, and in 2019, he was removed. Uh, on since 3/7/19, he was suffering from ill. He got admitted in the hospital, and treatment continued for about more than a year, my lord. Meanwhile, the proceeding was initiated ex parte, and he was removed from service. It's all about the ex parte order. The inquiry was ex parte, and the decision was also taken ex parte. And since he was under the treatment, while the writ petition was filed, all the medical documents have been enclosed. And initially, he was suffering from jaundice.
Was any appeal filed?
Since the appeal period, I did not I did not know about the taking of the proceeding against me, all these things, because I have not received anything else. Then subsequently, in the after being removal, all this, after happening all these things, when I was got cured, then only I got the whole documents from one messenger, which is not known to me in the later part. Then the 30 days, the appeal period, I could not file any appeal. Now, only at this juncture, the instead of paying the family pension, now under the NPS, they have paid 5,000 something else from October itself, 2024. And they are saying that, yes, we are ready to pay, but because of the removal order, we could not do anything else. Once any order comes from the court, we'll do it for the family pension. And they have paid one lump sum, 1,82,000 to the family.
Where is the order of removal?
Lordship will find. Page 40 starts from 42, Lordship. Annexed G.
Which writ petition?
Of the earlier writ petition, 2043/21.
2043.
The second writ petition, we are confined to only pensionary benefits and others. Lord. The order dated 14/11/2019. It's a case of unauthorized absence.
After removal, you get pension.
After removal, now only the wife of the deceased, this writ petitioner, she has got the only NSP, National NPS, 5,000 per month. Now two kids are there, the 3 year, one is 4 years and another is now 6 years. Their school going, nothing, nothing has been received, from the authority. Only now 1,82,000 have been paid to her, saying that once regular family pension is received, if any, then the whole amount has to be refunded. And of course, they are giving the wiser the views that saying that if any order comes from the honorable court, we will do that.
And what ground are you challenging
Now, my lord, here, firstly, I'm challenging, my lord, since this impugn order was issued ex parte, no charge sheet was submitted, nor the inquiry report was supplied. All these things are there. This is different thing. But as a whole, my lord, there was no inquiry. There is an expert inquiry, and since the question of the supplying of inquiry report, all these things doesn't happen here. They did not supply anything, and the lordship is aware that
No, it is a case of desertion. Desertion.
first there is a desertion, and after 2 months there is a removal.
So desertion means you are not there.
No, my lord, since desertion lordship is the section is very specific, my lord. That desertion, as per the section, that is, I have stated, my lord, in my paragraph 18, Lord, kindly see. And that too, some stigma has been given to me, my lord, saying that 1,20,000 amount has been given to the petitioner, and he has paid the whole amount for this SAB bill. But here they are saying that only something else has been paid and others had not been paid. But all these documents have been submitted to the authorities concerned. Now, Lordship will see the desertion section 74, section 74(2) of the ITBP Act, Indian Indo-Tibetan Border Police in 74, Lordship will find
Here,
in
we need a
inquiry.
We'll need the act. Section.
74
Section
74, my lord, regarding desertion. (73) is a capture of deserter. And 73, Lordship, kindly have it first.
Yes.
Whenever married law.
Yes, please do.
Yeah. Whenever any person subject to this act deserts, the commanding officer of the unit to which he belongs or is attached shall give information of the desertion to such civil authorities as, in his opinion, may be able to afford assistance towards the capture of the deserter. And such authorities shall thereupon take steps for the apprehension of the said deserter in like manner as if he were a person for those apprehension a warrant had been issued by a magistrate, and shall deliver the deserter when apprehended into force custody. No information, nothing else. Whereas, my lord, the office was 5 kilometer distance from my house, my lord, hometown. My lord. Any police officer, too, may arrest without warrant any person reasonably believed to be subject to this act and to be a deserter or to be traveling without authority, and shall bring him without delay before the nearest magistrate to be dealt with according to law. Nothing was done, my lord, in this regard. My lord, police station is nearby my house, 1 kilometer distance. My lord. That was not done, my lord. An inquiry into absence without leave, my lord. Now 74. When any person subject to this act has been absent from duty without the authority for a period of 30 days, a court of inquiry shall, as soon as practicable, be appointed by such authority and in such manner as may be prescribed, and such court shall, on oath, affirmation administered in the prescribed manner, inquire respecting the absence of the person and the deficiency, if any, in the property of the government entrusted to his care, or in any arms, ammunition, equipment, instruments, clothing, or necessaries, and if satisfied of the fact of such absence without the authority or other sufficient cause, the court shall declare such absence and the period thereof of the said deficiency, if any, and the commanding officer of the unit to which the person belongs or is attached shall make a record thereof in the prescribed form. 2. If the person declared absent does not afterward surrender, is not apprehended, he shall, for the purpose of this act, be deemed to be deserted. Whereas these provisions where there was no court of inquiry, I do not know about all these things, and no such the police officer has come to my place, my lord, since only less than 1 kilometer the police station is there, my lord. Had there been any inquiry from the SP or any intimation to the SP or the officer in charge, certainly I would have been available, or they could have seen my condition, my lord, that since I was.
Was there any order passed with respect to Desertion?
Yes. The
Available
record,
here.
the record I have with me, my lord, it reveals
a
that.
part of the pleading. Is it a part of the pleading?
No, my lord. In the process of declaring deserter, whatever procedures were required to be followed, that was followed, my lord. The apprehension roll was issued, UI was ordered, and subsequently he was declared deserted.
These are all in pen and paper.
Of course, it has to be in pen and paper. How will
My lord, the records.
you are suffering from what?
Jaundice, my lord.
Jaundice.
Jaundice.
So you
Jaundice and
why did you desert the unit?
Lordship.
Why did you desert the unit?
No, my lord, I was suffering from fever and stomach pain, my lord. So immediately, I to the immediate authority, I intimated him on 3rd of July 2019, my lord. I intimated that I am suffering from so and so, so and so. Then I have come to home, my lord. This Likavali, I was detailed there in Likavali, my lord.
Robert, report. You can't come home because you are ill or not well. You have to apply for leave.
No, my lord, when the Honorable Supreme Court also said that if there is if the person comes home for illness or anything else, my lord, that cannot be treated as the misconduct, or that cannot be a.
Mr. Kapse, if you are a member of a Supreme Court, you are not well, you are suffering. You have to present yourself before the authority will make place you before the medical board and then take a call.
No, that part, my lord, when person was totally serious, my lord, because he could not first time in the first half he did the duty, my lord. In second half he could not do the duty, my lord. So he immediately come to home, my lord. That is why, my lord, then medical, my lord.
You have deserted.
That's, my lord, already I
You're
intimated.
absent without leave.
This is not deserted, my lord, and
You're
to be
absent
deserted,
without
my lord. To declare the deserted, my lord, this sections, the condition has to fulfill, my lord. This section 40.
Already, if you have not deserted, then you are absent without leave.
Absent without leave, yes. Absent without leave, my lord. This absent without leave because of this illness, my lord. This is and my lord, lordship, kindly have a look.
See, as a discipline board, you don't have casual leave.
My lord, that's true, my lord. When this person is suffering, totally suffering, and he was serious.
This is a matter of fact. How do we know what is the degree of your suffering, and is it a case that there is no medical facility within the unit or near the unit?
he came to
Who did you report? Your commanding officer or unit
no
commander?
commanding officer not there. My lord, commanding officer he was in Basar, my lord, and I was detailed in Likabali, my lord. Likabali, lordship, have a look at the page. I have stated, my lord.
You show us that you had followed the procedure prescribed for going back to your home.
Your lordship, transit camp in church at Likabali, my lord.
Where is that?
Para 3, lordship.
So show us any document, order, application.
Lordship, kindly have a look, my lord. That is para 3, my lord. Though my posting was Basar, my lord, but I have been detailed in the transit camp, my lord. Lordship, para 3, lord. The accommodation arrangement of the officers in traveling, purchasing of food items, etc. My lord, this para 3, my lord. This work I have been given, my lord. That the petitioner said that apart from his usual duty, he has been assigned duties to the miscellaneous work like accommodation, arrangement of the officers in traveling, purchasing of food items, vegetables from Silavathar town to unit headquarters AP, payment of electricity bill, etc. under the instruction of the transit camp in charge of Likavali as directed by the unit commandant of 49 ITBP, Basar.
You come to para 4?
Yes. Saturday, he felt uncomfortable as he was suffering from bacillary dysentery with abdominal pain, for which he took advice from the doctor of Damages Civil Hospital after the.
Did you bring this to the notice of your superior authority?
My lord, that part, my lord, immediately I informed my authority in the Likavali itself, my lord.
Where? By how?
By telephonically, my lord.
That is not sufficient.
My lord, however, somehow he could manage to attend the official duty till 3719. While he became serious in the evening on 3719 for his abdominal pain, etc., he could not report for duty. Thereafter, considering his serious problems for his ill health condition, he was treated under the doctor on so at Dhemaji Civil Hospital, and after due treatment, as he found to be acute jaundice, etc. In continuation of his medical treatment, the petitioner health condition was deteriorated and totally he was bedridden. Lordship, kindly have a look the documents, my lord, which I have enclosed.
We are not to disbelieve your document. We are only asking you that you are in a unit. You are not posted. You are not given solitary posting. Were you given solitary posting? No. Your statement in para 2 is to look after these work for persons of the unit. See? Purchasing so and so, paying electricity bill under instruction of transit camp in charge at Nikabad. So you are in the transit camp.
My main office was in the Basar, my main posting.
All right, you are posted at transit camp.
Yes.
So transit camp will have an in charge.
Yes, that
you bring this to the notice of the in charge that you are suffering and you need medical attention, medical help.
Verbally, I inform my lord. Then
how do you prove or disprove that statement now?
My lord, since it has been my lord, verbally it was informed, and I have come to home, my lord.
No, you have come home,
and
but will it amount to desertion, absence?
No, my lord, since desertion, my lord, to declare the desertion, this section 73 has to fulfill, my lord. Before desertion, section the condition of section.
All right, 73 may not. If we say 73 not applicable, then what about absence without leave?
The 7 now. The absence without leave, my lord, the reasons behind, my lord, because of this medical problem, my lord, there was absent, my lord. And to that effect, Lordship, this removal order, which was passed under under rule under rule 25, my lord. My Lordship, kindly have a look at my paragraph 18 of the writ petition, my lord.
The respondents tell us, what process have you taken for,
My lord,
we have treated him to be deserted, desertion,
yes.
deserter?
My lord, before declaring deserted, my lord, apprehension, initially, my lord, the father of the notice was issued to the father of the petitioner on 16/7/2019, which was received by the father of the petitioner on
Did you
19.
inform the civil authorities?
Yes, my lord. Thereafter, an apprehension rule was issued in 5/8/19, my lord. After which,
Where are these?
my lord, this is in the record. The record.
Why have you not included here?
My lord, the records were called for. So we have the original records. The affidavit we have stated.
Where in the affidavit have you stated that?
This 25 of the affidavit, my lord, the apprehension rule issued was sent to the in charge Likabali, my lord, stating that the movement order for reporting of force number so and so Sanjeev Palwar was issued, but the official has not arrived at the headquarters. The official has remained absent for 15 days, which is a punishable offence under the rules and regulations. Hence, you are requested to direct your son to report to the 49 Battalion. Otherwise, action will be taken as per the rules. My lord, at page 27 and 28, the letter was handed over to the father of the petitioner under his signature. Page 27 and 28. Letter received. Yes. The issuance of the apprehension role, my lord, the CUI was conducted for my lord, the without leave. So the process is that the first the apprehension rule is issued. If still the person does not report, my lord, then he is declared deserter. Here, my lord,
Rule is issued, but he has to be served.
it was served, my lord, the father at page 28 and 29, which I have, my lord, we have annexed page 27 is the translated copy, which reveals, my lord, that the letter handed over today to Shri Dilip Kumar Kalwar, father of Constable Sanjeev Kalwar, by LO, and receiving details is to sent to WhatsApp.
No, it was not
This is
received.
the original.
What is his postal address in his rolls?
There is a wrong ethic. There is no ethic.
Hindi it is there.
I have not received it.
But we'll get it next week. Order hearing. If your record,
well,
don't give up the record.
Yes.
Order hearing. 17th.
it was not served. And in Dinanath case, Lordship knows that the address has to be proper, it has to be served properly. All of you.
We'll take it up next week.
My lord, can it be after Richardson on 15th, my lord? Otherwise, I will have to concentrate. 15th, July.
We have already fixed 17th.
My lord.
17th.
17th.
The case for removal.
Yes, ma'am. Removal from.
Because we have only 5 minutes left.
In fact, my lord.
Right. 17th of July. Okay.
The side has some problem. 29th, then, my lord.
29.
29th.
29? 29.
Great.
My lord, it is a matter of arbitration, and this matter has already been heard twice or thrice by your lordship. And the matter is very urgent, and let it be fixed on 17th. 17th, 6 months. As the top of the list of hearing.
Top of the list.
Of the year.
The hearing. Right.
Can it be on 19th, my lord?
19th.
Let it be 19th. Top of the
Top
hearing.
of the hearing list. 19th.
Right.